I got nightmares in my head, I fear. Thoughts build up until I can't hear. And my mind fills up into a creature, and it haunts me somewhere much deeper. I got nightmares in my head, I fear. The thoughts build up until I can't hear. That my mind fills up into a creature, and it haunts me somewhere much deeper. Hey guys, and welcome to closing arguments in the Karen Reid trial. The court proceedings haven't resumed. It does seem like there's some kind of drama playing out. We'll go to that in a moment. Let's have a quick look at what Karen said yesterday when she left the courtroom.
Thoughts going into deliberations tomorrow?
Just be positive, try to feel strong, be with my lawyers and my parents, and just have faith. We've left nothing on the table. I've worked every day at this for 2.5 years, so there's nothing more I can do.
Thank you.
2.5 years. What is very interesting is that she didn't testify. If you were falsely accused of murder, would you have nothing to say? Do you think she made the right decision not testifying? What do you guys think? And then this is also from yesterday, the crowd of supporters, Karen Reid supporters wearing pink. Quite a lot of people, right? Okay, someone says the court is live. It looks like you're right. Let's go straight to that. Oh, there's Karen. Something is going on in court today besides the closing arguments. Let's just go back to that. It says over here, a large crowd are gathered outside, and then over there, this is one of the jurors that was previously questioned by the judge prior to another juror being dismissed. She's standing with her arms crossed. The juror just shrugged her shoulders as the judge said something to her. Now she steps away from the bench. The judge and the lawyers are talking. So there does seem to be some issue with the jurors. As we know, today's closing arguments, but it seems like Karen is doing like a victory lap already. Supporters are doing. And so the question kind of is, did a juror perhaps interact with this crowd of supporters? Did she express some kind of support for the prosecutor or for the defense or for Karen? The juror has a determined look on her face. She's standing with her arms crossed and her back against the wall as the judge and lawyers talk. One of the court officers just led her out of the courtroom. The judge leaves the courtroom. The lawyers return to their tables. Reid and her attorneys are standing in a huddle. Does seem like something is up, doesn't it? Karen says, I believe she made the right decision as the reasonable doubt already presents without her speaking a word. Okay. So the judge right now is still in chambers. So, wow, day 31, starting off with drama, starting off with controversy. Any thoughts on whether, do you think the juror in question is a supporter of Karen Reid or what's the word? positive towards Karen Reid, or not? Do you think the issue is that she's shown some kind of bias for or against Karen Reid? What do you think it's about? Certainly is an unexpected development. That does make sense. Angela says, per court TV, a juror was dismissed. That makes sense. And it's quite scary that 31 days into this trial, there's apparently been some misbehavior from a juror. Certainly doesn't feel like it's going to bode well for the next phase, which is it being handed over to the jury, right? Jazzy says that's a hard call. With that town, it won't be hard to influence them. So it does seem like Canton is split. Is it down the middle or slightly down one side? Are the jurors as split as the town is? I guess we're going to find out. Karen cutting a bit of a lonely figure. She's dressed in quite a sort of somber color. Seems quite concerned. She did say on camera that she really wants to testify, and one wonders whether she was convinced not to or whether she changed her mind. One wonders. Perhaps the juror said something on social media and that was identified or highlighted. Perhaps that juror participated in some way in the support campaign, right? Please do vote in the poll if you haven't already. The last time I looked, it seemed like most of you seem to support Karen Reid, seem to believe in her innocence. Let's just get the latest. Karen Reid. So yeah, it looks like 1/3 versus 2/3. Karen's just looked at the camera. Okay, that's not a great start. So yeah, about 2/3 of you, 65% believe she's innocent, and 1/3 think otherwise. Okay, well, so it appears the Commonwealth, let's just have a look at that. Appears the Commonwealth is making an argument about this juror, Laura McLaughlin. The judge is reading from a book. Reid is once again leaning. The judge is reading from a book. Reid is once again leaning forward, arms crossed. Yannetti is arguing. So this is all about throwing a juror out. What do you think? I get the feeling the prosecution want her out and the defense want her in. Hi, Ellie. Good to see you here. So the format for today is 2 hours. There'll be 1 hour for the prosecution and 1 hour for the defense. And I'm not sure if they'll do it the same way as a lot of the other cross-examination, closing arguments. Sometimes there's a little bit at the end where the prosecution get a final chance to briefly respond to the defense case. I'm not sure if that's going to take place in this courtroom. There's sometimes a little bit of variations in how courts are run, but I would expect it to be basically an hour prosecution, hour defense, and then maybe another 10 minutes or so from the prosecution. I guess we'll see. For those just joining us, it seems like there's an issue with a juror and some possible juror misconduct on the cards. So let's have a look at the family arriving in court today.
Any thoughts heading into the day, Karen? What do you hope for today?
I think she said relief. She's feeling relieved that it's over. I must say I'm feeling the same way. I'm definitely relieved that this trial is going to be done with quite soon. That's John O'Keefe's family. You know, it's 31 days, but it's not like one calendar month. It's kind of been going on for at least 2 months, right? It's 31 kind of court days, which is a lot more than 1 month. Okay, so it looks like that is it.
I've never seen.
Every evening, this is where Boston turns.
It's an
Okay, so what I want to show you guys are just some of the last witnesses that testified yesterday. Have a look at that briefly. And so it was the defense side was kind of thin. You had 31 days of trial, and I think 2 days were really the defense case, and also not Karen Reed testifying. So yesterday we had Andrew Rentschler testifying, and he said that there's not enough evidence to say what caused John O'Keefe's fatal head injuries, right? He's a biomechanical engineer and accident reconstructionist. And then he said the following. He said, certainly it's not consistent with getting hit by the car and ending up where he did, even if the ground is somehow hard enough to cause that type of injury. What I would have really liked to have seen in this case are like animated reconstructions. You actually saw some YouTubers doing that. I would have liked to have seen that being sort of fed into a program and then basically animating it. Anyway, the vice president and director of biomechanics, Rentschler, said that the company's crash reconstructionist looked at several documents. Once you get up to that speed, you start to see fractures. You see significant ligament and tendon damage. Jackson asked if O'Keefe's head injuries, which included skull fractures stemming from the back of his head, were consistent with being struck by a vehicle at 24 miles per hour. Then he said, it is not, sir. It is not, no, sir. Still dealing with that. Okay, and then he said, if there's enough force to cause a skull fracture, then there's going to be certainly enough force to cause injury to the rest of the body, including injuries to the cervical spine. I don't know whether that applies if there's it's a partial, like a glancing blow, like if the edge of the vehicle hits him. But one thing that is certainly makes you think is Why did he not have bruising, right? It could be that that there was bruising, but the cold actually kind of contained it to some extent. Another kind of interesting question is what actually killed him, the cold or something else? Trish says the defense reconstruction experts were amazing. Okay. Jackson asked if the head injury was consistent with falling backward from a standing position onto a hard surface. He said that's possible. That's one of the possible scenarios that would create the injury mechanism. You fall backward, strike your head on concrete. Another scenario is that you get hit and you bang your head sort of forward, right? You get hit and your body sort of goes forward before it goes backward. But you would imagine that would have left a real dent on the vehicle. Answering another question from Jackson, he confirmed that grass and dirt would not produce the same amount of force as concrete. Jackson turned his attention to O'Keefe's arm injuries, asking if the SUV's taillight damage was consistent with striking someone's arm. Rentschler said the ARCCA found the two were inconsistent for a number of reasons. So he talks here about if you struck at that speed, you're going to see significant damage to the arm, subcutaneous lacerations, bruising, and fractures. For most people, the center of mass occurs at your umbilicus or your belly button. So wherever your belly button goes, that's where your body is going to move. Christine, thanks for joining us. He said that propelling O'Keefe's body several feet into the yard would require a force acting at O'Keefe's center of mass. That would also likely be injuries to the side of the body in that scenario. Lally noted that the ARCCA's report said that O'Keefe's arm injuries would be highly improbable if O'Keefe had been wearing a jacket. He asked whether Rentschler was aware O'Keefe was not wearing a jacket when he died. Rentschler said, I believe that came to light afterward. And though he said that didn't affect his findings. So Lally talks about the possibility of a sideswipe collision. Bear in mind, the damage to Karen Reid's vehicle is kind of just really the taillights, basically just on the one side of the vehicle. And then he said, if there's a sideswipe impact with a pedestrian and a vehicle, there's going to be very little damage to the pedestrian and very little movement. And then the defense rested after that. So that was basically it. That was the summary. The damage to Karen Reid's taillight was inconsistent with striking O'Keefe's head. Crash reconstruction said, and obviously that was a defense expert. Then we had this guy, Daniel Wolf. Let's try and do that. Wow, a juror was dismissed per the court clerk. So a juror has just been dismissed. That's interesting. Quite a crucial time for that to happen, right? Quite a crucial time. One wonders what the story is. From that juror's body language, we heard that she folded her arms, that she didn't seem very happy. You can kind of imagine that she wouldn't be. Okay, we're back.
All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court in the Farley County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22-117, the Commonwealth versus Karen Reed.
All right, good morning again, counsel. Good morning, Ms. Reed. Good morning, jurors. I don't know how many times I start in the morning by saying we appreciate your patience, but today is one of those days. Again, we appreciate your patience. You may notice that one of your fellow jurors is not sitting with us today. I can assure you that that is because of an issue that is just personal to that juror and has nothing to do with any concern of any of you. So please disregard that, okay? I do have to ask you those 3 questions. Were you able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively.
Wonder what the
Were you
personal
also able
reason
to
is.
follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So now we're at the point of the trial where the lawyers get to do their.
Thanks,
closing arguments
Fedigus.
for
Thanks
you.
so much. Appreciate
I've
it.
given them each an hour to do so, and they both tell me that they want me to give a 5-minute warning. I just don't want you to think I'm scolding them when I.
Oh, for
give a
speaking to the
5-minute
press.
warning,
That's
so they
interesting.
let
It's
me do
interesting
that.
that the judge doesn't mention that.
When I was a trial lawyer, I tried a lot of cases in this courtroom. The thing I liked least about the trial was just before I stood up to give my closing argument, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. So because of that, you have to put your notebooks away. All right, so if you just put your notebooks away and just listen, and though the closing arguments are not evidence, they're certainly a very important part of the case. And we've all seen how hard the lawyers have worked for this long period of time. We've all noticed that you've paid great attention throughout the entire trial.
Who do you think is going to do closing arguments for the defense?
In Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last. So we will hear now from Mr. Jackson.
Thank you, Your Honor. Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on, but the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way. Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Karen Reed and the tyranny of injustice. It's a job you didn't ask for, probably a job you didn't want. But it's the greatest responsibility we have as citizens here in America. Lest the government stop answering to us and we start answering to the government. And woe betide any one of us who might find ourselves in the crosshairs of a Michael Proctor. Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions. What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl. You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie. Over and over and over, they and others were caught deceiving you. Big things, small things, it didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left. They'll magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way. Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that can happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift.
But I didn't mean to use all cats
Have
there.
secret
Sorry,
friends and
guys.
family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage. Hide personal relationships. Make this case cut and dry and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl. It's not that it could happen. It's that every single one of those things I just mentioned did happen right in front of you. But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative instead of the other way around? Looks a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks. Drag her through the mud and make sure you attack her character. And that's what you saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Read. They desperately resorted to calling witnesses to talk about Karen Read and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall. What are the words that every single person who testified in this case used about Karen Reed and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up until the time Karen Reed dropped him off and he walked into 34 Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all-powerful Canton family, it's easy to say, I didn't see something, because how can that really be challenged? Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house. And when he was caught and asked to describe that man, he had to. It was a little bit vague. You remember what he said. He was tall with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial that was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data. Look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monotonic time, it aligns perfectly. They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32 after she'd left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie. And Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him. So it all fits. And Ryan was right behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34 Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you.
So just a quick thought, and I know I'm breaking in and I know I'm interrupting, but no matter which side you're on, what do you make of the fact that Karen Reed goes home and John O'Keefe remains where he is? Just that thing. So let's say you accept that they had a good relationship. Let's say you accept that they weren't arguing. Why would she go home without him? What do you think about that? And if they did that through mutual consent and mutual agreement, and they did so amicably, why would they do so? Compared to if she'd gone with him into the house, what would that show? Just wondering what you guys think about that. In other words, without knowing anything about the case, the fact that this couple part ways, and at the time that they part ways, or close to the time one dies, does the parting of ways mean anything else, or does it mean nothing? Just wonder what you think about that.
You wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial. How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone that went missing? Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview. Brian Albert, Brian Higgins show up drunk at the waterfall. They'd been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed to John. You could see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John and he motions for him. Come on, come with me. And then at 12:20, he texts him, "You coming here?" This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in. Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped in one of his testimony that he provided. Quote, "I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers. Remember that testimony. So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long would it take for Brian Higgins to say to John, you know, your girl's been texting me. A push, a punch, a fall, pull Chloe off his arm, and now it's done. What is that? 5 seconds? 10? Doesn't take long at all. And then the panic sets in. It wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening at the Albert household. Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk? What was so important there? He couldn't even get his own story straight. First, he said it was administrative work. Then he said he was moving cars. Then he said it was a factor of both. Is it both? Was it neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jen McCabe admitted, yeah, I didn't see her there. But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out? Recall what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. And Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth. But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day, at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed, but 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds.
So another aspect in this case that is sort of fundamental to it, right? So I'm just trying to thin slice here in a way. So one of the things is that they go their separate ways. Does that mean anything, right? The other thing that is significant is it's a scenario of two people that are intoxicated, that have had quite a few drinks, two people, and they're going into a house where the party is going to continue. And so just through the lens, through the sort of porthole of intoxication, what is more likely, that someone driving and people are intoxicated, you're going to have an incident, or that the intoxication is actually irrelevant and someone goes into a house, and you can almost imagine that you can take everything away, that there's no party, no one's getting drunk, someone goes into a house and then gets beaten up. It's got nothing to do with intoxication. Or is intoxication relevant? If so, is it relevant to what happens inside the house? Maybe John is rude, maybe John is belligerent, maybe John is whatever. Or is it relevant to the vehicle and Karen and that side of things? And just like what I'm trying to get you to think about is, what is more likely in terms of intoxication? Do people generally get hurt driving while intoxicated, or going to a party kind of while intoxicated? Something to consider. That just kind of the average when things happen.
Now that call is odd and suspicious enough in just in and of itself, the fact that the call was made. But what's even more incriminating is that both men,
Hey, Chelsea.
both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, they're butt dials. Amazing. But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't he? Remember on cross-examination when I was asking him, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Well, let's test that out.
So also what's interesting with this case is you've got two competing realities, and certainly there are problems with both. You know, no matter what side you're on, there are definitely issues with the evidence on both sides, with the stories on both sides. But what to me is really interesting about this case is you've got two competing realities, but there is only one reality. And so how good are we at discerning the one from the other? Are we able to see the evidence, or are we seeing our own bias? And whatever the answer is, it's quite concerning in a broader context. In other words, let's say you are right, or let's say you are right, or somebody is right. That means there's a substantial amount that may not be right, which means there's a substantial amount of people that can't see reality. They're two competing realities, and people just can't tell which one is real. That's quite worrisome. That means there's a large group of people around us who, when you vote and when you do whatever, they're seeing a different reality. Is that good for us? Is that good if half of us can't see what's going on? Is that healthy?
Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. Okay, fine. And by the way, come back over. I need help moving something heavy. How long did that take? 15 seconds, maybe? But the odd behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion, the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time when all this suspicious activity was happening at the Albert house and the McCabe house? 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was nobody on that lawn, period, at 2:30 a.m. And what other suspicious thing happened that night? By 3:30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view of where John's body would ultimately be discovered. Who's the only person in this case that you've heard about with a Ford Edge? Brian Albert. Remember, as you're thinking about this, the basement at 34 Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence. And that side fence is easily accessible to the front yard at the side of the house. Which side of the house? The side where John's body was found. And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabe's, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John. He walked into 34 Fairview, and that's all she knows. She knows nothing else that was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back. He's not responding. Minutes start to pass. 1 minute turns to 2, 2 turned to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. Being peeved eventually turns into being pissed.
Jeez.
By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe he'd do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail.
So here Jackson is acknowledging basically discussing Karen being furious, right? Not peeved, not angry, furious. So we've dealt with two people go their separate ways. And I think some of you were like, yeah, well, that's normal. People, there's nothing to see there. Then we spoke about, is intoxication a factor? Is it intoxication a factor in terms of going into the house? But then the third level of it is, it seems to be common cause that Karen was furious, not irritated, not angry, like extremely angry, and intoxicated. And I think she was still intoxicated by 5 o'clock that morning. What does that mean? What does that tell you? What do you guys say? I mean, basically, I guess what I'm asking is, if Karen, and I'm not saying anything about if she knew or if she didn't know, or if she did something or if she didn't, just the fact that she's furious at that time, is that relevant?
Illustrates frustration, aggravation, all the normal responses anybody might have, you and I might have. But little did she know. The next open voicemail has Karen.
So if you say, yes, she was furious, and then you say, well, let me ask you another question. Did the vehicle reverse at 25 miles per hour, yes or no? So someone was furious and did the vehicle reverse at 25 miles per hour? Do the defense dispute that? So do the defense say that that's just an error? So where does that come into the story? Why did the vehicle reverse at 25 miles per hour, or did they say it's just an error in their telematics? When last did you reverse a vehicle at that speed? I mean, I can't remember if I've ever done it. I probably have done it at some point, but I can't remember when last. Can you remember when last you reversed a vehicle at speed?
Parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But
I wonder what you say about that, Fadicus. Is Karen's state of mind relevant? Or do you say, yeah, well, she was a bit upset? What do you think?
Still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the
So there is Karen. She's got her arms folded, which is quite kind of strange. Yannetti also listening.
the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids?
Karen sort of looking at the jurors while this is going on. Obviously, she would. How is this landing with them? Is it resonating with them? Do they? What is their body language?
Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail,
I don't know if you can see that she's breathing quite deeply. You can kind of see her chest rising and falling quite a bit. I don't know if you noticed that.
you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up. She's realized that he hasn't come home and he hasn't responded to a single text, not a single call. And anger quickly turns to panic and abject fear. She's so distraught, she reaches out to him again. John, where the fuck are you? She says through tears and desperation. And at 6:03, the question was answered and her worst fears are realized when she finds his body laying, dying in the cold in Brian Albert's front yard.
And you see how she's breathing.
You heard her. You can feel the grief. You can feel the raw anguish. You can see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times.
Yeah, and I mean, that's also interesting, is that she calls him 53 times. Is that significant? Is that a little or a lot?
She called him 53 times before finding his body.
Is that a sign of concern? So I do want to just pause on that point. So did she call him 53 times because she's concerned, right? And let's say you say, yes, of course, she's concerned. But then you can take that into court now and say, and this is just my observation, when he's talking about John out there and kind of going over, why wouldn't you be crying about it? I mean, surely it's a really traumatizing moment. This is the beginning of a horrible nightmare. Someone falsely accused, someone that you love is dead, someone that you love was out there suffering. This is all a big misunderstanding. Why wouldn't it be heartbreaking and devastating? In other words, if the 53 calls are because she loved him so much, cared about him so much, then why aren't you getting a sense of that from her? You can say that she's innocent and so on, okay, but what about her attachment to this man that she was in a relationship with? Is that evident? And you might say, well, have you watched the whole trial? Answer, no. So maybe you can say, yeah, it is evident. She did love him. I know that there's some talk of infidelity on both sides. So again, is there fury and anger because of real infidelity, or is there fury and anger because I don't know where you are? In other words, is it deep the emotions, do they run deep because of serious issues, or do they run, or do they not run deep? It's just someone being, couples argue. It's no big deal.
Think about that. The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times. It makes no sense. What does make sense is that she emotionally.
Do you notice how she kind of glanced down there? Now, I've just heard somebody else saying that in another case, it makes no sense. It makes no sense. On the one hand, yeah, it doesn't make any sense. So if you meant to kill someone, why would you care about it, or why would you call about it? Well, we know Jodi Arias deliberately killed Travis and then called and left a voicemail. We know that Scott Peterson did the same thing as well. We know that Chris Watts did the same thing as well. You might say, well, but they didn't call 53 times. And you might say, okay, so that's a sign that she did care about him and was worried, but not worried enough to go there, right? Not worried enough to go there alone and find him. The other side of it is, if you think about it, isn't that quite elaborate? 53 calls is quite a lot of kind of calling and whatever. And then think about how elaborate the sort of the defense is, that they, what is it, 50 people that are part of a conspiracy. That's also quite elaborate, if you think about it. In other words, you can either say that she's a very emotional person, or you can say there's a lot of drama and pageantry. Well, which one is it? If she's so emotional, why is she not emotional right now on camera? I'm just saying, if she's someone who is so overwhelmed, she doesn't seem to be showing much emotion, and she seems to be hiding her emotion. I don't think she's not feeling it. I think she is feeling it. But why is she not showing it? Maybe lawyers told her, try not to show emotion. But why not?
Moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually...
So I also want to just interrupt him here. I really wish the prosecution had gone first, but he started his argument saying, look the other way. That's how he started it. This happens, look the other way. This happens, look the other way. And I wrote it down. And if you think about it, what he's saying now is look the other way. He's saying the incident didn't happen with a vehicle, didn't happen in front of the home. It happened at John O'Keefe's home. Look the other way. Look over there. Should we? I mean, was any evidence found there? And I mean, there were CCTV cameras. Does it look like the vehicle did hit the other vehicle? Yes, it does. But was any glass left there? I would have liked to have seen a recreation done, because that could have really easily been done. If the vehicle did back into it, would the light have struck the vehicle, or would another part have struck the vehicle? Something that nobody seems to, by the way, I'm a photographer myself, but I'm certainly someone who pays attention to details. And what is quite interesting in that footage is it looks like the person in that vehicle, Karen, actually has her head turned. She's not looking on the screen. That's my impression. I could be wrong, but it looks like she's actually turned and looking behind her while she's reversing. Some of us do that. But you do have a screen that can provide you with all the information you need, how close you are. The other thing that's so interesting with that is, wasn't the Lexus telling her when she was reversing that you're getting very close to another vehicle? I don't know about you, but I've got a vehicle that alerts you when you're getting very close to another object. And so was it the first time that night that she was being alerted that you're close to another object? And was it the first time that she overrode that alert system where she said the vehicle's saying beep, 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 and she just keeps going? Because that is exactly what had to have been happening. And why? So why did she override it? Right? And the same applies to perhaps earlier that evening. How do you hit a vehicle when your onboard system is telling you just how close you are, and you are looking behind you? Well, wasn't it done? It's a question. Wasn't it done deliberately?
Tried to tell you that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. We could see that tire move. I'm only going to show you one series of exhibits during my entire closing.
So something else that I remember in the early days of this was that people said I don't know, it was like a strange argument that people were saying that she reversed into the vehicle and look, there was no damage to the taillight. Like when the vehicle drove off, it was like, look at the taillight, it actually is whole. So it was almost like they were saying, yes, there was a collision, but it was with the vehicle, but it didn't damage the taillight. And then you see in the video, look at the car going off, there's the light, and there's nothing wrong with it. Well, actually, if you look at the video closely, you can actually see it is damaged. In the beginning, it's not that clear because it's sort of quite bright in the frame. And that's kind of where you go, is there something wrong with your eyes? Like, I can see it. Why can you not see it? And that's where you wonder, are people dishonest, or do they just have like attention deficit disorder? Obviously not everyone, just a lot of people. Because if you watch that footage from the beginning to the end, closer to the end, you can actually see that the light on the left and the light on the right from the rear perspective aren't the same. And so there obviously is damage at that point to the light. But that seemed to be early days where they were saying that the light wasn't even damaged by that. Then later on, the story became that it was damaged by that collision. All of this, of course, does create a certain amount of doubt. So when was it damaged? Did the police damage it?
But it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words.
So there you can see it looks, they look almost identical, but then a little bit later, they don't look identical at all. There's definitely something damaged there.
Very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished when Dighton Police Officer Barrows walked into this courtroom. He's a sworn officer. He's not associated with Kenton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, that tail.
I just want to stop there again. Now, I actually don't appreciate, Faticus was saying that he's a really good lawyer and maybe he's making a good argument, but I don't appreciate how that was presented, because what you see in those images is from the same footage. In other words, if you watch the video footage and you see what looks like a whole tail light and you keep watching it, as the vehicle goes a bit further, that's when it looks like it's broken a little bit later. It's from the same video footage. What he's presenting there is what appears to be a mismatch. And if I was in the jury and I hadn't been paying attention, or I've not remembered the case very well, I'd be like, wow, that does seem odd. 1 minute the light's not broken and then it is. What's going on here? Well, just watch the footage, the original footage. So showing a still image, I think there was a bit tricksy. Good defense tactic, but is it actually telling the truth about that particular footage?
Light was not completely damaged.
Hey,
It was
Iceland, good to
cracked,
see you
a
here.
piece was missing, but not completely damaged. Take a look at this photograph and tell me, which one looks like Officer Barros's description? The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so. You'll recall that after John's body was discovered, Lank, a very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades. At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud. But still, you've got to imagine that the Alberts had to be stressed, what with that whole thing about a dead body being on their lawn. That might get some attention. And they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls? Is he going to look in the basement?
See you soon, Chelsea. Thanks for joining
Michael
us.
Proctor answered every single one of those
Welcome,
questions.
Cotton Star. Good to have you with us.
Nope. He's a Boston cop too. And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall. A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks.
So if you believe in the conspiracy, this is the part I don't understand. So let's say there's this big organized effort to frame Karen Reed. Why do they want to frame her? Like, what has Karen Reed got on them? Did she know about some serious crime that the police committed and there's money somewhere? Like, what is the incentive to frame Karen Reed? Like, what is the big grudge and sort of how does that dynamic work? You might say Karen Reed is framed. Okay, but what's the motive to frame her? Is she a dirty cop? Is she a criminal? But now bear in mind, not in terms of this case, something else. And so what's the motive to frame Karen Reed? Because if you think about it, if that's what they were doing, they only got themselves into trouble, putting a body in front of their own home. That's not framing Karen Reed. Framing Karen Reed would be taking the body to where she was and leaving it in that driveway, wouldn't it? Wouldn't that be framing her?
Are not invited. We protect our own. It's us or it's them. And by the way, who's she after all?
Hi, Heidi. Thanks for joining us.
This is going to be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, becomes intentional, which means it becomes corruption. The defense spent some time, we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for just a quick second. Because this was a concerted effort by Michael Proctor to falsify the time the car was seized so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene. But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16 when he finally had to tell the truth or some version of the truth. Those first pieces of taillight were not found until after 5:40.
The other side of this whole story is if Karen Reed is innocent and if Karen Reed did nothing, then who killed John O'Keefe? And I mean, answer that question with one name, two or three at the most. But basically, so who is being accused of murder? Who is the prime suspect alternative? Anyone got an answer to that? Like, okay, so it's like O.J. Simpson. O.J. didn't commit these murders. Okay, so then who did? Right? Who did? Like, someone was killed. So if this person's innocent and that didn't happen, then what did happen? Okay, so then who did kill one person? Who did kill John O'Keefe? And so is it a double thing? You also don't like John O'Keefe, so that's the motive. What's the motive there? And then you also want to frame someone, so you've got to have a double motive, right? So then you say, yeah, well, there are people with a double motive. How many people? So you have a big group of people with a double motive. They've all got the same motive for two different people. But, okay.
45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Loughran? You met.
It's also interesting that, you could say, but wasn't this just an accident? Or didn't she just want to nudge him and, she didn't really mean to hurt him or she didn't mean to kill him? And you might say, well, okay, so did Karen have a motive, right? How did Karen feel? But yeah, I mean, I don't think you can hit a person that hard, as Iceland says, and it be an accident. The speed and the severity of the impact show it was deliberate, whether she was hit by a car or by somebody else,
Madam,
by a person.
Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Loughran, he never disclosed his name in a single report. He hid him. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Alberts. If it were up to Proctor, you literally never would have heard of or from Brian Loughran. That's a scary prospect. I want to touch briefly on the additional physical evidence, or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley.
I think he's
She
got
established to a
15 minutes
scientific
left.
certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that
Good
cocktail
comment
glass.
there,
She told you
Annette. Good
unequivocally
comment.
the glass on the bumper did not match the cocktail glass. They came from two different sources.
It's like what Tom Cruise says playing McCaffrey in A Few Good Men. He says, it doesn't know what I believe. It depends on what I can prove. And I know the law. Remember that.
The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor. So the glass on the bumper had to be placed there. And the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math. That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair, barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside. That would be a magic hair indeed. That magic hair means nothing. The DNA means nothing, and that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV.
So how do you think his hair was placed there? Like, how would you imagine that would kind of play out? Someone would go to John's body and then go to the vehicle and put the hair there. And so, again, in order for this case to work, you've got to have all of these kind of leaps. So a dog does something. There's a lot of people. All of it's possible, but the one on top of the other, on top of the other, on top of the other starts to stretch credulity, doesn't it?
Be inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that DNA. No DNA was found on the interior of that taillight. The taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that taillight or any taillight pieces. And no tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour.
So did they find any glass on John's body or in his clothing? Well, I think I know the answer. If they did, it was planted. Okay. So anything that is not going to be good, then it's a conspiracy. Okay.
With 1,000 pounds of pressure. We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the Sally port. Let's take that one, for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally port. Pretty important time, wouldn't you think? Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Juror Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall Mr. Lally asked
It's a good
Sergeant
point
Buchanan,
as well,
did you or Trooper Proctor
which is why
ever go
there's
at or near
some
the
doubt.
right side
Question
of that
is it
taillight?
reasonable
And while
doubt?
he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said,
Yeah, I must say, I would actually say it's legally weak on both sides. There's no doubt that law enforcement don't look terribly good, lots of bungles and lots of problems. But equally, I would say the defense case is pretty weak as well.
we never went anywhere around that taillight while he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward. And it was cleverly inverted at that. The timestamp had the proper orientation.
Thanks, Christine. Good luck with those taxes,
Had
eh?
to be removed, the video inverted, and the timestamp placed back on it. Which means that was done intentionally. That was not a mistake. And when
Yeah, this is the reality. And that's why the defense had such a brief case. They just have to show reasonable doubt. And there is quite a lot of reasonable doubt. The question is it sufficient? Is there enough reasonable doubt? And I would say there's a lot. Is there enough? I don't know. I know what I think, but let's suspend what we think and believe for a moment.
caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back in.
So something somebody said that I thought was really true was that the state spent so much time rebutting the defense's arguments that the defense actually ended up putting up a defense. And in a way, I think that played into the defense's court. Do you think that was the right strategy from the state to take on the defense's arguments during their prosecution? Because it would have otherwise been a much shorter trial. And that kind of opened the door to lots and lots of arguing and counter-arguing and details and so on, when I think you could have made this a much stronger case if you could have abbreviated it, made it as short as possible, and just focused on, literally just focused on the evidence, not on the conspiracy side, the police corruption, even countering that. Let the defense say whatever they want. The defense in the end called just a handful of witnesses. So I think if the prosecution had just focused on their case, it would have been a stronger case. That's my view. I mean, we don't know what the outcome is yet.
It's exactly the same, he said, as if we're stupid. Is it exactly the same, or is it exactly opposite? Ladies and gentlemen, you were lied to. There is no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case: lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor, and he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene. 0. Stephen Seraph, Sean Good, Stephen Mulaney, Michael Lank, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. They even used tools, a leaf blower. Not one piece of bright red taillight material was at the scene. Not a single piece, but incredibly, over the course of according to Michael Proctor, 47 pieces of taillight material would end up being found. some of which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony that you heard. Who else was there? Who did O'Hara?
I just want to share a little bit of my experience with the taillight. Taillights kind of have a weird character of their own. So I was at a shopping center. This was maybe, well, what was it, 4 or 5 years ago. I was at a shopping center where the distance between vehicles, and the vehicles are parked not like at an angle. They're parked literally bumper to bumper. And so literally what happened was I was reversing when another car was reversing. I saw the other car and stopped, but the other car kept reversing. And for some reason, he reversed quite far back. And so he hit my vehicle. And the crazy thing is his taillight shattered into lots of little pieces. There was virtually nothing left of his taillight. When you looked at my taillight, it had a slight crack in it. And I never even had it fixed. I mean, it was slightly damaged, but most of the taillight, the whole taillight was still there, was just a crack in it. So it's quite strange how taillights kind of have a character of their own as well.
Harris say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there who were unaccounted for. Massachusetts state troopers were there unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important, and I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate. Tully, however, claimed that 1 red piece was found. About 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up, probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about, those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not stop and shop bags, thank God. At least they've moved up from that. They've even got evidence tape on them. Who knew? There's evidence tape around here. So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the 2 red pieces together. Good so far. Then he opens up the second bag under Mr. Lowley's questioning. And you remember he hesitated just a second. Opened that bag and pulled out 1 piece of clear plastic. Then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened. And he quickly returned all 4 of those back into the bag, sealed them up, and we're done for the day. The next day, I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. Pulled out 2 red pieces of plastic. I said, you'll recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have had I not suggested it? And then he pulled a 3rd piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic.
I think he's got like 5 minutes left.
Right before your eyes.
It should be wrapping up.
Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34.
It's going to be going on for quite a bit longer.
Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the
another
course
10
of 3
minutes
weeks,
or so.
those pieces of plastic go from 0 to 3 to 5 to 47. Ever increasing in size with every single search. Now, knowing all that, ask yourself the looming question: who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sally Port video. I'll give you the timestamp, 5:37, and see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see.
So interestingly, when we started, well, obviously just the amount of people voting, the votes were about 2/3 Karen Read innocent. They're now closer to 60-40, still in Karen Read's favor, but a little more split down the middle. This is a very divisive case. Lots of very different opinions on it.
What he was doing. Higgins' own key swipes put him in the Sally Port that same afternoon and evening. And then the Sally Port video magically skips and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sally Port together. Where were they going? Remember O'Hara? Unidentified troopers in Canton cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic?
So one can only wonder, is the same thing kind of going to happen in the Rex Heuermann trial? Is Rex Heuermann going to make it corrupt cops? Because I think he could. Could he make it a specific cop that's committing these crimes and is framing him? What do you think?
Spent a long time talking about the compromised and altered and tampered and manipulated evidence, and now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Read pulled up to 34 Fairview, John got out of the car, she reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts. That's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Read's vehicle ever struck John O'Keefe or that Karen Read ever wanted to strike John O'Keefe.
Is that true? There's no evidence that she struck him. Is that true? Sounds like you're saying that as a fact. Is that true that there's no evidence that his vehicle struck her? It's quite a big statement. I don't know why we've been at trial for 30 days. There's no evidence that the vehicle struck him. Is that true?
O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house. That SUV was not damaged by hitting John, and John's injuries did not come from being.
And so that brings us to another, just thin slicing the whole thing. Was Karen Read's vehicle damaged that night? It's a simple question. Was Karen Read's vehicle that she was driving, damaged that night? Timmy, come on. Was it damaged? Was it slightly damaged, like really, really slight damage, or not? And then the next thing is the accusation here that somebody was hit by a vehicle, and that vehicle was damaged that night? Quite a coincidence.
Being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. And because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth. Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Scortibello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto pedestrian accident. That by itself is reasonable doubt. But the evidence and the truth goes far further. We introduced you to not one, but two thoroughly credentialed medical examiners or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was. There is no other possibility. And Dr. Sheridan, for his part,
so shouldn't the dog be on trial for murder? I mean, that's the perpetrator, right? Isn't it?
with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner who's triple credentialed in anatomical, forensic, and neuropathology. He told you that John's injuries are inconsistent with a motor vehicle accident.
So, it's fair to say that, and how can I put it? I'm not going to argue and say those injuries to his arm do look kind of strange. And yeah, you would imagine there would be bruising on his arm if his arm took the impact. Yeah, certainly. But by the same token, you'd say, okay, well, where's the evidence that it's from a dog? You might say, yeah, but it looks like a dog's bite marks, right? But where's the evidence of that? If the dog has bit him all over his arm, and you say all of these puncture wounds are from a dog, then, sorry, where's the saliva, dog hairs? It's got to have left some evidence, right? That if the dog had so much time to bite his arm, there's got to be dog hair somewhere, and dog DNA somewhere, but there isn't. Does that matter? By the same token, if you said, okay, but then fair's fair. Is there any DNA? And I know what people are going to say. Oh, no, that was covered up. Someone came and picked up the dog hair or used a leaf blower and blew away the dog hair. But by the same token, you could say, okay, no, fair's fair. Is there any evidence that he was struck by the vehicle? Yes, his hair on the bumper, the fragments of glass in his clothing, as far as I know, right? And so, just in terms of that, the DNA evidence for the one compared to the other, well, one is definitely stronger than the other.
Or incident. They're consistent, however, with a physical altercation. In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. Two of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rentschler, mechanical engineer and a biomechanist. They reviewed this case. They did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available, by the way, to the Commonwealth. They could have called them. They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe.
So just an observation I'm going to make. He looks down and he says that should be enough to establish reasonable doubt, and he kind of shakes his head just in terms of his body language. Can I play that again?
Sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case.
Did you see that? You would imagine that I'm just saying what I think here is that if he really believed that, that's a really strong point. That should establish reasonable doubt. I would want to look at the jury and kind of be like, that is establishing reasonable doubt here, guys. But he's looking down and he's shaking his head while he's saying it. I don't know whether, I mean, sometimes when you say there's nothing present, you would also shake your head. You know, there's just nothing here. You can sometimes do that. I just think him, from a presentation perspective, that could have been done a little bit in a stronger fashion.
So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony. I think I'm being kind when I say that Trooper Paul's analysis lacked credibility. Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the...
I was quite surprised that, to me, one of the most important parts of this case is the accident reconstruction. And the guy tasked with dealing with it on the state side seemed a bit of an amateur. Like, you would think they would have gotten a really strong witness, but the bottom line is he's the guy that that handled the evidence. I don't know whether they knew then that this case would go to trial. He was just kind of just going through the staff, kind of just procedure wise, and he happened to be up, but it certainly wasn't a very strong witness, that's for sure.
Absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him.
By the same token, if a dog had bitten the arm like that, you would imagine that there'd also be that sort of redness with infection, because it's a kind of puncture wound and a kind of a tooth is a fairly blunt, sharp object, if I can put it that way, and it's creating rip marks. And you would imagine that there'd be quite a lot of trauma to the skin, and the skin actually kind of looks fairly. I must say, I wish one could just go back in time and actually see how those wounds were made, because it does seem odd from any perspective.
Scratching his arm, even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement, before coming to his final resting place with his unbroken phone tucked neatly under his body. It's nonsensical. It borders on laughable. Compare that. So
another thing that I think is worth pointing out is whether the phone, in terms of the car collision scenario, whether the phone gives us any clues. So the fact that the phone isn't damaged, and you might say that doesn't make any sense. Why is the phone not damaged? Well, if it was in his pocket, why would it be damaged? If he landed on snow, why would it be damaged? If he was being framed, wouldn't you take the phone? Wouldn't you get rid of the phone? Because that would be evidence. That would be, in a lot of cases where people are murdered, the phone is removed from the scene. Suzanne Morphew, Maggie Murdaugh, Lacey Peterson, although they did find her phone, couple of examples. Shanann Watts, although they did find her phone, it was hidden away, but they did find her phone. But I'm just saying, you would imagine someone who deliberately killed someone would try to get rid of the phone, because that would show, for example, that he'd gone inside the house, kind of thing. Why would you let investigators have access to the phone?
That testimony to Dr. Dan Wolf and Dr. Andrew Rinchler, both PhDs in engineering, both top of their field in accident reconstruction, both published peer-review articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense. And these men are unrivaled in accident reconstruction.
Good
What
point,
did Dr. Rinchler say before he left the
D.
stand? This was even
Patterson.
under cross-examination. He said that the physics and the science don't lie. His words were, you can't deny the science and the physics. John wasn't hit by that car, period.
That's a good example as
The
well.
Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to his back, to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone.
Yeah, unless he was hit on the side of his body where his arm took the brunt of that hit. His arm in a jacket.
Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, the whole collision.
About another
That
6 minutes,
3.5-ton
guys.
SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get.
I was about to say that. It's true.
So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised and covering up.
5 minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is
Timmy,
answered.
do you think a
Every
dog
single
did this?
injury
Hmm?
is explained by that.
Think a dog did this?
Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? This festering malignancy that allows a lead detective and his supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they've targeted. Will that continue? And the answer should be not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats illustrate the quality and character of his investigation. Remind yourself how an, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat. talking about her bodily functions, her medical conditions.
So that's quite interesting. He's turning it into Karen being treated like a piece of meat, not John O'Keefe.
Calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object.
Well, that is exactly what they did. They did test the wound and they didn't find any dog DNA. Right?
And he went further by insulting her. He went further than insulting her, and he dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth, and I did that because that's what this case is about. Top to bottom, tip to tail, it's about the truth, not hiding it or concealing it.
So did you see that he's talking about the truth and he's shaking his head, looking down and shaking his head. The second time he's done it. Just play it for you again.
That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning.
Yeah, it comes.
About the truth, and I did that because that's what this case is about. Top to bottom, tip to tail, it's about the truth. Not hiding it or concealing it, but exposing the truth. The truth is immutable.
There again.
It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting.
See what I mean?
That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you. Not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies and the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt into a moral certainty, not even close. Ladies and gentlemen, Karen Reed is innocent. Do justice and find her not guilty. Thank you.
All right. Thank you very much, Mr. Jackson. All right,
Okay,
Mr. Lally.
Mr. Lally.
Thank you, Your Honor.
He's not quite as snazzily dressed as Jackson. He's not paid as much. Let's hear what he has to say.
I hit him, I hit him, I hit him, I hit him. Those are the words of the defendant. 4 times. You heard testimony from 4 different witnesses who overheard and observed those statements from the
Strong
defendant
start.
on January 29th, 2022. You heard testimony from firefighter Timothy Nuttall. He was trying to bag valve mask Mr. O'Keefe. He was working on resuscitative efforts to try to save Mr. O'Keefe's life. He asked if anyone saw anything or knew what happened, and the defendant said, I hit him, I hit him, I hit him, I hit him. Firefighter Anthony Flamati was asking if anyone had information on why Mr. O'Keefe was there in the snow. The defendant repeatedly said, I hit him, I hit him, oh my God, I hit him. Firefighter Katie McLaughlin was tasked by firefighter Flamati with asking for biographical information and for what the cause was of the traumatic injuries that all the firefighters testified that they observed on Mr. O'Keefe. She asked the defendant, and the defendant said, I hit him, repeatedly. Firefighter McLaughlin asked for clarification. You did what? And the defendant repeated, I hit him. Jennifer McCabe stated initially over the phone when speaking with the defendant that the defendant said, could I have hit him in the car while they're on the phone with Ms. Roberts going from Ms. McCabe's house to Mr. O'Keefe's house? Did I hit him? Could I have hit him? Once on scene, once asked, as Ms. McCabe described by an EMT, for name, age, things like that related to Mr. O'Keefe, what caused the trauma? She indicated in her testimony that the defendant said repeatedly, I hit him. You heard testimony from Officer Sarif, statements that he attributed to the defendant as saying that morning, this is all my fault. This is all my fault. I did this. This is what the defendant is saying on scene. Since then, the story's changed a little. But those were the words that came from the defendant's mouth on January 29, 2022, as John O'Keefe was dying on the front lawn of 34 Fairview Road, where the defendant had left him after striking him with her motor vehicle several hours before, and then left him freezing there in a blizzard. There's certain things that have come up over the course of this trial as far as evidence and testimony are concerned, little things. And what I would suggest to you, it's those little things that are quite telling as it pertains to the defendant's statements and the defendant's actions over the course of January 28th, January 29th, and beyond. I'm going to bring some of those to your attention as I go through, but just ask you to keep that in mind as far as when you're deliberating, when you're reviewing this testimony and this evidence. The little things matter. The little things start piling up in this case. Throughout the course of this trial, you've heard a lot of purported evidence or questions of witnesses in an attempt to distract you from the evidence in this case. It's essentially defense by obfuscation. It's a three-card monitor. Facts and the evidence in this case are your card, they're the Queen of Hearts. And so what I want you to, or what the defense wants you to do is not look at that card, look at anything else. Look at movement, look at this person, look at that person, look at text messages, look at this. Don't pay attention to the facts and the evidence, because if you do, what it will ineluctably lead you to is that the defendant is guilty of each of the three indictments before this court. The evidence and the facts of this case are for you, the jury, to decide. Using your common sense, using your life experiences as your guide through that as you go.
Using your critical thinking.
Before I turn to that evidence that I will submit to you ineluctably demonstrates the defendant's guilt, let me first just address Trooper Proctor. Text messages from Trooper Proctor are unprofessional, they're indefensible, they're inexcusable. However, as distasteful as those messages are, and their content is, I submit they had no bearing whatsoever or impact whatsoever on the integrity of the entirety of the investigation that Massachusetts State Police collectively conducted into John O'Keefe's death. As was asked of Trooper Proctor on cross-examination, these were texts from his personal phone that he never thought would see the light of day. He was asked whether or not he ever thought that he would be asked about these in a courtroom, put to him as sort of a safe space, a safe place for him to discuss, if you will. What do you not see in those text messages? You don't see any discussion or any illusion of any conspiracy of any.
Such a great point. So you've got these text messages, and it's like what is Jackson saying? He's looking at photos of Karen and this and that. And it's like, okay, but there's this big conspiracy going on where the text messages showing, hey guys, we must plant the DNA in a car. Hey, what are you doing? We need to do this. Where's there proof of a conspiracy? So you can say there's this evidence, and this is an argument against that evidence. Okay, well, prove your case of a conspiracy, and yeah, you can say it's not the defense's job to prove their case, just raise reasonable doubt. That's exactly what they've done. So you can say there's a police conspiracy, but we don't really need to prove it. Okay, then do you accept it? Do you accept it?
Framing of the defendant, of any planting of any evidence, no evidence whatsoever. Why? Because it didn't happen. There is no conspiracy. There is no cover-up. There is no evidence of.
So now notice how when he says that, how convincing it is, because he's looking at the jury and he's saying, and he's nodding when he's saying it, because it's a strong point that he's making, and he believes in the point that he's making. He's not looking down and shaking his head while making a how can I put it, a important point with effusively, right?
Any of that beyond speculation, rampant speculation and conjecture on behalf of the defense. Two things can be true at the same time. They're mutually exclusive. The texts from Trooper Proctor are distasteful, they're disrespectful, they're unprofessional. There's no defense to them. And the defendant killed John O'Keefe. Turning to the evidence, let me first talk a little bit about John O'Keefe.
He also raised a good point there, is that you need to sometimes think in a subtle way, which means two things can be true at the same time that are somewhat contradictory. In other words, the good guys aren't all good and the bad guys aren't all bad. There's some good in the bad guys and some bad in the good guys. It's not all black and white. And I think that's a conversation that's missing from both sides that are arguing, Karen Reid is completely innocent or the police are good or whatever. Both of that's not 100% black and white, right?
Heard a lot about him over the course of this trial, about his selfless story, his family and friends that loved him, including his adopted niece and nephew. You heard a lot about the lives he touched and the different people who he had friendships with. You heard a lot about from those particular friends and from his family. Turning to what I would submit to you as a timeline. This may be a little hard to see up here. What I'm going to go is from left to right. January 28th, 2022, 9:49 in the morning, Karen and John begin fighting over text messages. 2:24.
So can you see how Lally is using specifics far more, certainly at this stage, specifics in terms of the timeline, in terms of words used. And I've noticed this happens a lot in courtrooms, especially where the prosecution ultimately wins out. The defense don't really use very many exhibits. It's all kind of wishy-washy. It's all kind of cliches and aphorisms. The prosecution are able to dip liberally into the evidence because they've got evidence. That's one of the big differences between a solid prosecution and a solid defense. A solid defense can rely on specific evidence liberally, and that should be enough if it is true.
5 p.m. in the afternoon, the defendant texts Mr. O'Keefe, "Tell me if you are interested in someone else. Can't think of any other reason you've been like this." John texts back, "Nope." 2:25, Mr. O'Keefe texts the defendant, "Things haven't been great between us for a while. Ever consider that?" This is also testimony that you heard through multiple sources.
So that's quite a big statement to make January 29. Things haven't been great between us for a while. So it's almost like this is a point where they are taking stock. You kind of get the feeling he is definitely taking stock of the relationship.
Whether it be phones, whether it be from the children, whether it be from other friends or family members as to the relationship in the months and weeks leading up to John's murder. 2:32 p.m. John texts the defendant, "Sick of always arguing and fighting. It's been weekly for several months now." He then texts the defendant, "OMG, stop calling." This is during the time frame that Trooper Garino was talking about, with 18 phone calls, most of which were rejected, some of which were missed, and a couple of which were answered over the course of this afternoon as she's.
So who kind of comes across here as the bully or the victim or the perpetrator or the who wants in and who wants out? Where Karen says, "So you're not into this anymore." If you say that, what are you actually saying in terms of a relationship? Who would you say was more into it than the other?
Continuing to needle and try to engage him in a fight that he doesn't want to have. 2:33 p.m. The defendant texts John, "So you're not into this anymore." 2:34 p.m. John texts the defendant, "I am not answering. Stop calling." The defendant then texts John, "Then stop starting with me." 2:38 p.m. The defendant texts John, "I'm going to grab a drink in a bit." 2:38 in the afternoon. Around 3 p.m. is the testimony you heard from Erin O'Keefe in regard to the defendant texting her, asking if she can go out without her husband, Paul, asking him to go out for a drink. This is while Erin O'Keefe testified she was waiting for one of her children at the bus stop, picking that child up around 3 o'clock in the afternoon.
It's quite a statement. Wish I didn't speak to another O'Keefe after, well, I'm not sure what the relevance of that is.
Also the point in which the defendant says to Ms. O'Keefe, "Wish I didn't speak to another O'Keefe after 2004. 7:30 p.m., you have Mr. O'Keefe and Mr. Camerano arriving at C.F. McCarthy's, with the defendant arriving at 8:51. 8:58 p.m. is when the defendant receives drink number 1 at C.F. McCarthy's. Vodka soda.
Is this at all acknowledged in the defense case?
Tall cylinder glass, lime, and a strong.
Got the exact times here.
9:13 p.m., drink number 2. 9:20 p.m., drink number 3. 9:33 p.m., drink number 4. 9:57 p.m., drink number 5. 10:22 p.m., drink number 6. 10:29 p.m., drink number 7. 7 drinks from 8:58 p.m. through 10:29 p.m. when she receives that last drink at C.F. McCarthy's. The drink that she indicates to Sergeant Mechanic and several others on the next day that she did not take with her from C.F. McCarthy's to the waterfall, which several individuals at the waterfall testify that she produced from her coat when she walked in, and that you can clearly see on the C.F. McCarthy's video her walking out the door with the same tall cylinder glass.
Oh, right. Dated years earlier.
Now,
Yeah,
keeping
that's,
understanding that
I
some
follow
of these drinks
now.
are not the full tall cylinder drinks.
That's what the 2004 has to do with.
Vodka, and then pouring them into the drink after she's consumed the drink. 10:54 p.m. The defendant and Mr. O'Keefe arrive at the waterfall, during the course of which, about an hour that they're there, the defendant receives drinks number 8 and drinks number 9. 12:10 a.m. From the waterfall video, you have Ms. McCabe, Ms. Kolakithis, and the defendant departing the waterfall together. Interestingly, around the same time, you also have the text and screenshot communications between Colin Albert and Allison McCabe in reference to him getting picked up at that time. You also have testimony from Brian Albert, Nicole Albert, Caitlin Albert, Brian Albert Jr. in reference to them sort of walking in from the waterfall as Colin Albert is walking out of 34 Fairview Road, gets picked up by Ms. McCabe, and then is driven home. 1 minute later, 12:11, Mr. O'Keefe is then on the waterfall video walking out with cocktail glass in his right hand. At 12:14 a.m., Mr. O'Keefe texts Ms. McCabe, "Where to?" 12:14 a.m., based on the fact that she's driving, and Matt McCabe indicated in his testimony that she should call him instead of texting while driving, Ms. McCabe calls John O'Keefe. Speaks with him regarding directions, sort of going over which way to come in, Chapman Street, over Cedar Crest, as far as coming into Fairview Road. 12:15:38 a.m., the defendant's vehicle drives by the Canton Library. You can see that on the video. 12:17:56, the defendant drives by the Temple Beth Abraham video. Again, you can see that on the video. Remember also the testimony from Lieutenant Tully in regard to the CSLI data and the ranging data in reference to it coinciding with what you observed, the black SUV from each of those respective videos. 12:19:32, Mr. O'Keefe enters 34 Fairview Road into his Waze app on his phone. 12:23 a.m. is when the defendant conducts a three-point turn on Cedar Crest and travels back toward Fairview. That's from Mr. O'Keefe's GPS native location data from his phone. Around the same time at 12:23 and 12:24 is when you have that testimony from Ryan Nagel, Heather Maxon, and Ricky D'Antono pulling into Fairview Road around the same time and pulling in behind the dark SUV. 12:25 a.m. is the last native location GPS data of John O'Keefe's phone. It's in that area between 32, 34 Fairview Road, where his body is discovered the next morning, in which there is no movement of that phone from that 12:25 a.m. period until Miss Roberts then picks up the phone on the grass underneath Mr. O'Keefe's body sometime after 6 a.m. What you have up on the screen right now is that data, those plotting points that Trooper Garino was testifying about as far as the movement of the vehicle. The movement of the vehicle as it comes down Cedar Crest, passes by Fairview, reverses direction, and then comes down Fairview, moving up, moving up, moving up, as the witnesses described, eventually stopping in that area of the property line between 32 and 34 Fairview Road, which happens to coincide with the vehicle control history database information from the Toyota text stream, which you now have up on the screen before you here, indicating that following that three-point turn, approximately 8 minutes after that, from Trooper Paul's testimony, as far as the mileage, 36 to 38 miles, matching up with the time that the vehicle is in front of 34 Fairview Road, that the vehicle travels in reverse, in a straight line, for 24.2 miles per hour, 62 and a half feet, with a minor steering angle change, which the trooper indicated was consistent with a pedestrian collision. At 12:30 a.m., you have that second triggering event 8 minutes after the three-point turn when the vehicle is in reverse at 24.2 miles an hour. 12:35 is when the defendant calls John, and that's unanswered. 12:36 is around the time that the defendant's phone connects to the Wi-Fi at One Meadows Avenue, so his home. 12:37 is when the defendant leaves this voicemail. So within minutes.
Now, I must say, you can say she's furious, you can say she's angry, but it doesn't really come close to hearing it in her voice. I mean, this sounds like, I think another way of thinking about it is, when she said, I wish I'd never met an O'Keefe after 2004, she's kind of saying, I wish, I regret this relationship. I'm so bummed out, to put it mildly. And that is a major, to say, I wish I'd never met someone is almost like saying, I wish they were dead. Right? And when you hear her voice here, does that sound like someone at the end of their rope, or do you think it's just someone who's a little bit irritated? Well, you're not coming home with me, no big deal.
Of that vehicle's data, going 24.2 miles an hour in reverse for 62 and a half feet, the defendant leaves that voicemail.
Good to see you here, Liesl. I agree with
screaming,
you.
John, I fucking hate you. 12:40 to 12.
I mean, in her own words, she said, I hit him, I hit him, I hit him. She's also said, I fucking hate you. Not, I'm fucking so heartbroken about this, but basically, I fucking hate you. If you fucking hate someone, do you have a motive? Do you have any animus? Are you bearing a grudge? Do you have some kind of bad intent?
42. Ms. McCabe is texting Mr. O'Keefe. She tries calling Mr. O'Keefe, gets no answer. If you recall from her testimony around this time frame, about 12:40, she was unsure whether the vehicle was actually still out front or if it had gone at that point. But she was looking for John because she had seen the defendant's vehicle in front of the house and no one had come in. So she was wondering where her friend, Mr. O'Keefe, was. 12:55. The defendant texts John, see you later. 12:59. The defendant calls.
So think about what we're dealing with here. We're dealing with the prosecution's closing is dealing with things that Karen Reed is doing, things that Karen Reed said. Are we dealing with what she said 5 years earlier or after the incident or some kind of vague stuff? It's stuff that was going on that night at the time that it happened. Is it relevant? Does the defense have any texts about a conspiracy taking place where somebody said, I hate Karen Reed? Because here you've got Karen Reed saying, John, I fucking hate you. Do you have someone saying from the defense side, one of the officers that apparently killed John O'Keefe, I really hate Karen Reed. Did anyone say that? Did they?
Leaves another voicemail for Mr. O'Keefe. Exhibit 637. It sounded like this.
John, I'm here with your fucking kids. Nobody knows what the fuck you want, you fucking pervert.
But somebody did know where Mr. O'Keefe was. The defendant knew exactly where he was. She had driven him there. She had struck him there. She had left him to die there. 1:02 a.m., the defendant leaves another voicemail with no content. And then she texts John, your kids are fucking alone. 1:09 a.m., the defendant texts John, I'm back in Mansfield. The kids are home alone. She's not. GPS, as far as it never disconnects from the Wi-Fi until the following morning. There's no indication that Ms. Reed left and went to her home in Mansfield at any point. 1:10 a.m., the defendant calls her parents. 1:11 a.m., she calls Mr. O'Keefe and leaves this voicemail.
John, I'm going home. I cannot babysit Amy. I need to go home. You are fucking using me right now. You're fucking another girl. Keep sleeping next to me. You're a fucking loser. Fuck yourself.
1:18 a.m., the defendant leaves another voicemail. Now about 1:43 or 1:45.
So just, I've heard people saying if she deliberately murdered him, why would she leave these incriminating voicemails? It just doesn't make any sense. She was drunk, right? She was drunk. So she wasn't making a lot of sense, right? That's the answer. Or that's a potential explanation for why someone is not acting completely rationally.
5 a.m. is when Julie Nagel testified that they were leaving the house. And she sees a large black object on the lawn near the flagpole while leaving 34 Fairview Road. Doesn't think much of it at the time, isn't expecting Mr. O'Keefe or any body to be out on the front lawn. 4:42 a.m. The defendant calls and speaks. The calls to her parents are finally answered. 4:49 a.m. The defendant calls Ms. Camerano, screaming, "Where's Mike?" 4:53 in the morning is when the defendant instructs Kaylee, Mr. O'Keefe's niece, to call Ms. McCabe. Why? Because the defendant doesn't have Ms. McCabe's phone number. Indicates that John didn't come home. We got in a fight, and I left him at the waterfall. Those are the first statements or the first version of events that she's able to communicate out to the world as to what happened to Mr. O'Keefe, where he is. We got into a fight. I left him at the waterfall. 5 a.m., the defendant calls Kerry Roberts, saying, John's dead, Kerry, hangs up the phone. 5:01, the defendant calls Kerry Roberts again. And it's at this point that she indicates, John's dead, he must have been hit by a cloud. 5:07 a.m., the defendant leaves One Meadows Ave. You have the video of that. It's number 153 in Exhibit 6. We'll get to that a little more in a moment. About 5:10 a.m., the defendant calls Kerry Roberts. Ms. Roberts starts calling hospitals, calling HCP, calling 911, something that you would do if you didn't know where Mr. O'Keefe was for all of these hours, that all of these other phone calls are being made and these text messages are being sent, and calling your parents, and all of these other things. No calls to 911 from the defendant. While John O'Keefe is laying, freezing, and dying from a brain injury and a skull fracture on the front lawn of 34 Fairview Road. 5:11 a.m., the defendant's vehicle is seen on the Canton Library camera heading towards the waterfront. Seems to be sort of retracing the steps. 5:18 a.m., the defendant's vehicle is seen at Washington Street and Chapman on the Temple Beth Abraham video, heading in the same direction that it was the night before when it was heading to 34 Fairview Road. 5:35 is when the defendant arrives at Ms. McCabe's house. Ms. Roberts arrives shortly thereafter. Both of them see the broken tail light at that time in the driveway. Now that gap of 5:18 to 5:35 is way too much time to be driving from the area of the waterfall to Jennifer McCabe's house. And as I indicated a moment before, heading in the same direction, same directionality, retracing the steps from the night before, heading towards 34 Fairview Road. Why is it that the defendant can see Mr. O'Keefe when they eventually get to Fairview Road and no one else can? It's because
it's a good point. Why can she see him and he's about to say and no one else can?
Because she knew exactly where he was. She had hit him and left him there the night before. And she had gone back during that time frame between 5:18 a.m. when she's seen on the Temple video and 5:35 when she arrives at Ms. McCabe's house. 5:33 is when the defendant, Ms. McCabe and Ms. Roberts, return to One Meadows Ave searching for John. 6:03 is when the defendant, no one else, spots Mr. O'Keefe's body buried in the snow.
Tell me, stop snoring.
Exhibit 12, indicating this cruiser camera video, which I know you've seen a dozen times. So where I'm starting it from this point in this card right here is the spotlight that Officer Saraf had to use in order to locate, even with the vehicle of Ms. Roberts parked right in the middle of the road.
Just another reminder, or another kind of, not reminder, observe how much the prosecutor is using evidence. He's not making kind of grand statements. It's not gift of the gab. It's not waffle. He's anchoring his narrative step by step, stage by stage, in the words, the times, the visuals, the facts of the case. Why is he doing it as much as he is? Because he can, because he's got so much facts at his disposal.
In the darkness, in the snow, in the blizzard, in those conditions, the defendant, sitting in the back seat of the vehicle, knows exactly where Mr. O'Keefe is, covered in snow, as you heard from all of the paramedics, from the civilian witnesses, from the first responders. The defendant.
Now, you may remember in the defense's closing arguments, Jackson made this big statement saying, there's no evidence that Karen Reed struck John O'Keefe. And I said, is that true? Is there absolutely no evidence that she struck John O'Keefe? And you remember what the judge said? closing arguments aren't facts. Closing arguments aren't evidence. So to make a statement like that, there is no evidence. Is there? Is there absolutely no evidence? If there was no evidence, there wouldn't be a trial. If there was no evidence, the grand jury would say, there's not enough evidence, there's no trial, thanks a lot.
Knows exactly where he is. 6:07 a.m., Ms. McCabe calls 911. 6:08, the defendant leaves that 4 or 5 minute voicemail, leaving the phone in the car for some reason to
Yeah.
Mr. O'Keefe's phone.
If it's bothering you,
6:23,
I'll send him away, but
6:24
he's
in the morning
snoring
is when
softly.
Ms. McCabe conducts those Google searches. 7:50 in the morning is when Mr. O'Keefe is pronounced deceased at Good Samaritan Hospital. 4:13 to 4:20 p.m. is when the defendant's SUV is towed from her parents' house in Dighton. 5:20 p.m. is when the search team arrives in the area of 34 Fairview Road to conduct the search of evidence. 5:30 p.m. is when the defendant's vehicle arrives at the Canton Police Department south. You circle.
Like, what's that about? Like, why is Karen looking at the exhibit and back like it's, I don't know, like what is she trying to convey? That it's a joke, that it's funny? What is she, what's that? Like, is there some kind of in-joke that I'm not aware of about that?
Back for a moment to Mr. O'Keefe, to his families, to his friends, and to his relationship with the defendant. You heard testimony from Paul and Aaron O'Keefe that they liked the defendant, that they thought he was good for John, thought he was good for the kids. All outward appearances of the relationship were good. You heard testimony from the children that that was not true behind closed doors. But Paul O'Keefe testified that he told the defendant's parents this, that he liked Ms. Rivera, that he thought that she was good for John, thought that she was good for the kids, weeks before John's murder. He even blew her a kiss in the emergency department at Good Samaritan as he was walking out and she was still being treated while they were there. Invited her over to John's house to grieve with him. Invited her to sit down with him while he explained to their nephew Patrick about John's passing. The defendant shows up at the house, abruptly goes upstairs with her father for a period of about 15 minutes, which is about half of the time that she spent there that morning grieving with the family. She left with a bag of her belongings, drove with her family there, and then took an extra vehicle in the height of the blizzard, around 1 o'clock in the afternoon, drives that vehicle all the way from Canton, where it was parked at her boyfriend's house, where she stayed over on many occasions, drove that vehicle or felt the need to drive that vehicle from Canton all the way down to her parents' house in Dighton at the height of the blizzard. You heard testimony from Aaron O'Keefe of the text messages in the phone call on January 28th. You've heard that Aaron O'Keefe called the defendant on the morning of the 29th because she was concerned for her. She wanted to know what was going on with someone she considered her friend. The defendant yells, "John is dead." Ms. Robertson grabs the phone and then updates Aaron O'Keefe as to what's going on with John. Aaron O'Keefe again calls back later because she's concerned for someone that she considered her friend. How does the defendant respond? These are some of the little things. Defendant indicates to Ms. O'Keefe that she just has to remember the bad times and indicates to her, "I don't think I'll ever see you guys." This is after she's done her quick in and out at One Meadows Ave and is now with her parents or with her father, driving that car, essentially taking the murder weapon from Canton and bringing it down to her parents' house in Dighton. She's indicating over the phone to Aaron O'Keefe, "I don't think I'll ever see you guys." Why? If she didn't kill John, why would she say that? You heard a lot of testimony about New Year's Eve in Aruba. You heard the testimony from Ms. O'Keefe in regard to them exchanging, her and the defendant exchanging text messages on the flight down, arranging times to meet up. And then the defendant telling Aaron via text message that she caught Johnny kissing Laura's sister in the hotel lobby. She got into an argument about it, and then they never met up. Meaning the defendant, Mr. O'Keefe, got into an argument about it, and she and Aaron O'Keefe never ended up meeting up in Aruba. You heard testimony consistent from Laura Sullivan, Marietta Sullivan, as well as the children. The kiss never happened. It never would happen based on the relationship, the godfather relationship that John O'Keefe had with Laura Sullivan, her family, and particularly Laura Sullivan's child. The defendant persists with this unfounded suspicion and accusations of infidelity in her text messages with Mr. O'Keefe, in her text messages with Mr. Higgins, where she's accusing Mr. O'Keefe of making out in the lobby with Marietta Sullivan. Both of the Sullivans and the children have the defendant and Mr. O'Keefe following this incident with Marietta Sullivan going into a room. Both of the children testified that they're in that room for about 20 to 25 minutes and they're arguing about the defendant indicating that Mr. O'Keefe kissed someone in the lobby. And you have Laura Sullivan's testimony about 20 to 25 minutes after her sister comes out and states her displeasure about the defendant. It's about 20 to 25 minutes before Mr. O'Keefe comes out, and then he and Ms. Sullivan have a conversation. Ms. Sullivan indicates that Mr. O'Keefe's phone is essentially blowing up, lighting up with calls and texts from the defendant. I would submit similar to the afternoon of January 28th. Mr. O'Keefe says she's crazy and he needs to take this and goes off from Ms. Sullivan has later conversations with Mr. O'Keefe on this Aruba trip, asks him if he's okay, asks him if he's happy. She indicated in her testimony that Mr. O'Keefe shrugs it off and says it is what it is. You heard testimony from the children about the arguments in the weeks and the months. And I know this is a displeasure to the defense counsel that the children came in and actually testified as to what happened behind closed doors in the house. They both recall frequent fights. They both recall Mr. O'Keefe trying multiple times to break up with the defendant, asking her to leave the house, the defendant refusing to leave the house. His niece, Kaylee, John tried to diffuse, tried to walk away, and the defendant would follow each time during each argument. They both indicated that Mr. O'Keefe had told the defendant that the relationship had run its course, similar to language within the text messages you have between the defendant and Mr. O'Keefe. That Mr. O'Keefe was sick of arguing, again, mirroring those text messages from January 28th, leading up into going out to see if McCarthy is eventually the waterfall, and the defendant killing Mr. O'Keefe in the early morning hours of January 29th. We have testimony in regard to the ring camera. Kaylee indicated in her testimony that John had had that for about a year. So during the course of 2 years or so of the relationship with the defendant, he got it while he was dating the defendant. The defendant had the security code for the garage. Neither of the kids had access to the camera. Trooper Garino checked the laptop and the desktop that were left after the defendant did the quick cleanup upstairs with the father, upstairs in the home. Neither of those devices had access to the ring cameras. John had access on his phone. The defendant indicates, if you recall, in some of those text messages in regard to the romantic kiss that she placed on Mr. Higgins earlier on January, whatever it was, during the Patriots. Mr. Higgins and Mr. Jackson was indicating weren't very good friends with Mr. O'Keefe, but had been invited over to his home for a Patriots game, at which time the defendant escorted Mr. Higgins out of the garage and placed a romantic kiss on him. But during those text messages, when they're talking about that, if you recall, the defendant is saying something or joking about something that Mr. O'Keefe had been looking at the videos and had been asking her if there was something going on with her and Mr. Higgins. And what was her response to that? I know where the cameras are. There are only 2 videos missing from that ring system. One being the defendant getting to Mr. O'Keefe's house after murdering him, and the other when the defendant is showing Ms. McCabe and Ms. Roberts the broken taillight, both of which, both Ms. McCabe and Ms. Roberts testified as having occurred. No video. The variety of stories that the defendant tells on the morning of January 29th. There were text messages and voicemails from the defendant to Mr. O'Keefe, 53 phone calls from 12:33 a.m. to 6:03 a.m. 0 phone calls to 911. The defendant calls Katie Camerano. The defendant calls her parents at 1:18 in the morning, 4:38 in the morning, 4:42 in the morning. The call then from Kaylee's phone to Ms. McCabe, because the defendant didn't have Ms. McCabe's phone number. Both Kaylee and Ms. McCabe indicate that the defendant initially indicates or says that she got into a fight with Mr. O'Keefe and left him at the waterfall. From this information, Ms. McCabe then testifies she starts to call her Julie Albert, because Chris Albert, Julie Albert, they live close by the waterfall. Maybe that's where he went. As the phone is ringing, this is a phone call that both Mr. Albert and Ms. McCabe testify was never answered. As the phone is ringing, her husband Matthew McCabe reminds her that they saw the defendant and Mr. O'Keefe and the car outside of 34 Fairview, so she hangs up. During this call, or during these subsequent calls, the defendant indicates to Ms. McCabe, maybe I hit him, did I hit him? She then calls Ms. Roberts at 5 a.m. on the dot, indicates John's dead, hangs up the phone, calls back a minute later, indicates that Mr. O'Keefe was now hit by a plow and that he's dead, and then indicates further that she's drunk and doesn't remember. She tells Ms. McCabe about the cracked taillight before they even get in the vehicle and go anywhere, as you recall the testimony of Matthew McCabe, indicating that he had some concerns about them driving around.
If you think about that, wouldn't being concerned about the taillight, if you were innocent, wouldn't you just not even mention it? You wouldn't even think about it. You'd be like, how is he? How is John? What is happening to John? What is her main concern? It's the taillight and also what it potentially shows, isn't it?
In a vehicle with a damaged taillight in the middle of a blizzard. Ms. Roberts' testimony that she saw the broken taillight in the driveway at Ms. McCabe's house, and that it was consistent with what she observed in the photographs that were shown to her of it later in the Sally Port at the Canton Police Department garage when the search warrant is executed on February 1st. You have the text messages between the defendant and Lord Sullivan from January 29th, in which the defendant indicates to Lord Sullivan that John is dead, indicates that we found him in the snow at 5 a.m. And every indication is that he was found in the snow by the defendant, Ms. McCabe, and Ms. Roberts around 6 a.m. 5 a.m. would be about an hour before. 5 a.m. would be between that time where the defendant is unaccounted for, heading in the direction of 34 Fairview Road, 5:18, 5:35. Little things. The defendant asked Ms. McCabe to Google how long to die in the cold. She did so at 6:23 and 6:24 in the morning. You have the testimony of Ms. Hyde and Mr. Whitfield as to SQLite databases, P-list databases, Knowledge C databases, state DB tabs, as far as all of that. Also from Trooper Garino as well. These searches were unequivocally done at 6:23 and 6:24 in the morning, and not at 2:27 and 40 seconds in the morning. They were not deleted by a user. That is not what deleted means. Frankly, Mr. Green, the last question that I asked Mr. Green is, was he aware that Cellbrite, and by Cellbrite, the person who designed that being Mr. Whiffen, had to alter exactly how their software worked because of people like Mr. Green misinterpreting the data as he did in this case. And what did Mr. Green say? Yes.
Good point.
But those questions, as far as how long to die in the cold, I would submit mirror the questions that the defendant asked firefighter Whitley in the back of the ambulance, if you recall those. She asked firefighter Whitley how long to die in the cold without a jacket. She knew how Mr. O'Keefe was dressed. She knew when she left him to die in the cold how he was dressed. The defendant made statements to firefighter Becker that the last time that she saw Mr. O'Keefe, they were in an argument. Again, in the back of the same ambulance as firefighter Whitley. You have testimony from firefighter Woodbury. Same kind of questions. If Mr. O'Keefe could be alive without a jacket. You have the testimony from each of these firefighters as to sort of the vacillating emotional state of the defendant that morning. What you have.
I really like that he describes the vacillating emotional state of the defendant. Now, tell me, is that true to say that? Is he lying, exaggerating? Is it untrue? Is it unfair? You guys do know what vacillating means, right? And I think that's also something one's got to look at, is just say, was that taking place? Was there a vacillating emotional state of the defendant? You might say, no, I don't think it was. Okay, so in terms of this police conspiracy, was there a vacillating emotional state of multiple people who had animus against both John and Karen? Were they also just all riled up and pissed off and caught up about something? Okay, so if it's true, what is the something that they're caught up about? If there's something so terrible that you're willing to kill one person and frame another person, what is this thing that they're so upset about? How come we don't even know? There's a conspiracy, okay, but about what? And so you've got to compare the motive for the conspiracy to the motive and the circumstances of the alternative. Do they match up, or is it okay just to say, no, I believe strongly that this could have happened?
Testimony from firefighter Woodbury is that despite all that, there were no tears that he observed from the defendant at that time. What each of those first responders indicated is that the defendant repeatedly stated, is he dead? Is he dead? Not, is he okay? Is he going to be okay?
That's also a very good point. Not, is he okay? Is he dead?
How is he? Any sort of questions about the medical condition?
Does that indicate potential guilty knowledge, saying, is he dead?
Is he dead? That phraseology repeated over and over and over again.
So just to come back to vacillate, what does vacillate mean?
Vacillate.
It means to waver, to dither, to be uncertain. Is she feeling uncertain about the relationship? Is she feeling uncertain about his feelings? Is she teetering between being in, or is he teetering between? Is she divided, doubtful, unsure? Is something unresolved going on? Is there shilly-shallying, dilly-dallying, certainly wavering from his side? Is there fluctuation in their commitment? What do you think?
Vacillate.
That's what's such a great word.
And when you take into juxtaposition that phraseology, text to Laura Sullivan, found him in the snow at 5 a.m. The unaccounted for time heading in the direction of 34 Fairview Road, 5:18 to 5:35. The repeated questioning, firefighter Whitney.
It is understating it, but it's basically a neutral term, which is nevertheless true.
Firefighter Woodbury asking Miss McCabe to look up those things in her phone. She's looking for confirmation, is what she's looking for. When she asks over and over again, is he dead? Is he dead? Is he dead?
I hit him, I hit him, I hit him. Is he dead? Is he dead? Is he dead?
You have the testimony that you heard from Ms. McCabe and Ms. Roberts. I say them together because as far as these two women were concerned, they did not know each other really at all. The only time, as they both testified to, that they had ever spent appreciably together prior to January 29, 2022 is when Mr. O'Keefe nicely took them out for sneakers because he had some sort of deal at a Reebok's outlet or something like that to sort of try to pay them back for the help that they provided him and the children. Jennifer with respect to the niece, and Kerry with respect to the nephew. But they're both contacted by the defendant in the early morning of January 29th. As Ms. McCabe testified, John was my friend. I love John. He was an amazing guy. At the waterfall, Mr. Albert said going home to have a drink with his son, Brian Jr., if anyone wants to come. Open invitation to the table. She said to Mr. O'Keefe and the defendant, "You guys should come." Both the defendant and the victim indicated that they wanted to come and that they were coming. She describes the phone calls and the text messages that she receives from Mr. O'Keefe, that she's providing directions. She indicates she's providing them directions to go down Chapman. She describes how that is. And you've heard this testimony from a couple of different witnesses as far as the steepness as you're going down Chapman, going down Fairview of coming off of Chapman, that you first go down a big steep hill. It flattens out for a little bit, and then you go down a second, 2 hills going down on Chapman, matching the GPS native location and the health data as far as where Mr. O'Keefe's phone is, a half mile away from 34 Fairview Road at the time that his health data is recording that he's ascending or descending 3 flights of stairs. You hear the testimony from Ms. McCabe as far as the last time that she spoke to Mr. O'Keefe.
So that's really interesting. I have to say, when I was listening to the defense closing argument, I thought, wow, that's quite a strong statement. Why is there this flights of stairs scenario? And we certainly had the same kind of evidence in the Chris Watts case. Have you ever driven in your car and your phone says, "Well done, you've gone up a flight of stairs," or something like that? Have you ever done that? And sometimes when you go over rough terrain, that it seems to your car kind of vibrates. Have you ever had that happen to you where you're driving and the fitness thing on your phone activates? Ever experienced that?
Still trying to provide directions to Fairview because Mr. O'Keefe has never been there before, and neither has the defendant, which is further corroborated in Trooper Garino's testimony as far as the vehicle passing by Fairview and then coming back in on the other side, having to reverse direction. But she's giving directions, and she indicates that she uses a house that Mr. O'Keefe will be familiar with, that belonging to Bella or Bella's mom. Bella's mom is an ex-girlfriend for a short period of time, a long time ago. However, in the defendant's mind, it's so prescient on her mind that she's still talking about it the next morning or later on that morning when she's riding, going towards Fairview Road with Miss Roberts and Miss McCabe in Miss Roberts' car. She's still talking about it at that time. It's that much on her mind. Miss McCabe indicated that she looked out and she saw the vehicle initially in front of the front door, as did Mr. McCabe, as did Brian Albert Jr., as did Julie Nagel, as did Ryan Nagel, and the vehicle moved up several times or several spots to where it was then positioned. Initially at some point in front of the door, then it moves up further so that it's in the area of the fire hydrant and the flagpole where Mr. O'Keefe's body was discovered later on that morning, at least by Miss McCabe and Miss Roberts, and then moves up further beyond that. And I say that in the sense of it moves up further beyond that with sufficient distance for it to then go in reverse for 62.5 feet at 24.2 miles per hour, striking Mr. O'Keefe and leaving.
Well, I must say, I thought I didn't want to be pedantic, but when Jackson said 25 miles an hour, I was like, wasn't that 24 miles an hour? And he's just said now 24.2 miles an hour.
Leaving him where he was found later on the 29th. Again, the testimony from Ms. McCabe that about 12:40 when she's texting him, she indicated in her testimony she couldn't be certain if Mr. O'Keefe was still out front or had left at that point. She wakes up to a phone call from John's niece, Kaylee, at 4:53 in the morning. This is from an 8th grader, 14-year-old girl. That's why she answers the phone at 4:53 in the morning. She then hears the defendant screaming loudly over and over again, Jen. John didn't come home, got in a fight, left him at the waterfall. The variations, the different iterations of that story as it evolves and changes over the course of that morning. Ms. McCabe then indicates to the defendant, "We saw you outside of my sister's house." Then she starts yelling, Jen, did I hit him? Could I hit him? Then they start discussing, or the defendant brings up her cracked tailbone. Then both Ms. McCabe and Mr. McCabe hear the defendant screaming outside of their home. at about 5 o'clock in the morning, or shortly after 5 o'clock. They go to Mr. O'Keefe's house. And both Ms. McCabe and Ms. Roberts indicates, and you heard this testimony from a number of different witnesses, friends and family of Mr. O'Keefe, that he had a rule, pretty strict rule in his house as far as you take your shoes off when you come in the house. And so what did Ms. McCabe and Ms. Roberts both do when they're entering in that house on January 29th? They take off their boots, they come out in the snow, they take off their boots in the mudroom, and then they walk in. What did they both indicate that the defendant did that morning when she came back to the house? Walked right in with the shoes. You hear that second voicemail.
Interesting
After
detail.
the defendants arrived back at One Meadows Ave, after her phone is reconnected with Mr. O'Keefe's Wi-Fi. And you can hear the footsteps. Part of that may be in the garage, part of that might be in the house. Why is it that the defendant has no issue with wearing shoes in the house when Mr. O'Keefe has that?
That's really,
Because she knows where he is.
that's interesting.
She knows it's not an issue. He's not coming home because she hit him with her SUV.
Remember what I said about contempt? That's
Ms.
contempt.
Roberts and Ms. McCabe frantically sort of running around the house looking for Mr. O'Keefe. Defendant's not. They then get in the vehicle. They drive back towards Fairview Road. And again, the defendant from the back seat of the vehicle immediately sees the defendant, starts pulling and kicking on the door, and runs in sort of a beeline straight over.
Yeah, it was 24 miles per hour. That's what it was. Still fast.
To where Mr. O'Keefe is laying on the front lawn. We have the testimony from Ms. Roberts as far as John's phone. John's phone, when the firefighters pick him up and you recall.
Just a quick observation. There are only 90 people in chat. I don't think chat ever really went over like 105. Yet there are 253 votes, right? And if you divide that by 2, that's barely 100 could have voted yes or no. So it does make you wonder where those votes have come from. It is definitely interesting.
Several witnesses testifying about that, pick him up on the scoop stretcher and then bring him over to the ambulance while they're conducting the resuscitative efforts trying to save Mr. O'Keefe's life. Well, Ms. Roberts indicated that she observed underneath it, only the phone, but the phone on the grass in the area that is completely covered in snow in every other area except under Mr. O'Keefe, which I would submit indicates how long Mr. O'Keefe has been there. Now recall, around 12 o'clock or so is when it starts to snow and it starts to stick a little bit. And you heard all that testimony. And I know it was a lot of testimony about snow and a lot of testimony about weather, but there's a purpose to that. There's a point to that, okay? As far as the grass underneath Mr. O'Keefe's body, where his cell phone was, Ms. Roberts observed some 6 hours later after it starts snowing, is still visible only under Mr. O'Keefe where his body is, which I would submit as evidence to you as to how long he's been there. Now,
And
on
also
top
that
of
his body heat may have
you
melted some
also
of it.
have hours of ring videos of the driveway as far as shoveling and Paul O'Keefe and other people snow blowing and shoveling and all those kinds of things. There's a purpose to that as well.
You notice he doesn't have to read his notes like Jackson was. He knows this case off by heart. He's lived this case. He, you know what I mean? He's really got all of the his narrative on the tip of his tongue. It's also not like he's talking in broad strokes. He's talking about details and facts and evidence, specifics, but he's able to do it without referring to notes.
If you look at those, if you look at the video of the defendant crashing into Mr. O'Keefe's vehicle at a speed of anywhere from 0 to 5, which even Dr. Wolf would indicate would not cause the damage to the taillight that was observed in this case. You know what you don't see? You don't see snow move off Mr. O'Keefe's vehicle when they come into contact. You don't see any red or clear plastic pieces in the snow. And if you look at those stills, not the ones that counsel put up there during his closing, but if you look at each of the video and the stills.
That's exactly what I said, it bothered me the way it was put on the screen, that if you just look at the video from beginning to end,
you can see the damage consistent with the taillight at each.
That's exactly what I said. And that's a little bit tricksy and mischievous from the defense to break it up like that. You are manipulating evidence, court evidence, to make it look like it's inconsistent, aren't you? Why not just show it? If there's nothing, if this is your argument, just show the evidence. Why do you need to selectively choose pieces of it?
Each and every point. You see the damage consistent with the tail light from the 507 video. You see the damage consistent from the 822 video from Lieutenant Ray from the cruiser camera video when he's pulling into the driveway. You see the damage consistent from the Dighton video.
That's also a very important point, is that why is there so little snow under John O'Keefe? If he was killed in the house and then brought out there, well, then that shouldn't be the case. So the earlier that he was there, the more you would expect that there wouldn't be snow under him, for two reasons. One is it's snowing that night, but he's already lying on the grass, and so the snow can't get to the grass. That's point number one. Point number two, his body heat to some extent is going to melt the snow that is around him. And of course, the later he gets into the position that he's in, the less snow there's going to, the more snow there's going to be, and the less able he's going to be to melt more snow. And so, doesn't that make sense? As Pauline says, the snow aspect shows that he lay where he was struck. And in a weird way, it's almost like the John Benet Ramsey case. This case can turn just on this evidence, in theory.
At the defendant's home, you see the damage consistent from the right here.
Yep.
February 1st, 2022, when the search warrant is conducted, Ms. Hartnett removes all those pieces from the vehicle. The weather is also important when it comes to the hair. The magic hair, as Mr. Jackson likes to call it. See, the magic hair was actually frozen to the vehicle.
I like how he has kind of sarcastically referred, because sometimes sarcasm is justified, referred to the magic hair. And then he says, how is it possible that it's there? Because it was frozen in place. That does actually make sense. That was another good argument from the defense. Certainly made me think, yeah, how could a hair hang around in blizzard type conditions?
As was the glass to the bumper, because the vehicle looked like that on the left when it was caked in snow, when Officer Barrow saw it in the driveway in Dighton as they were wading through 1.5 feet of snow, walking up, because remember, they didn't even pull into the driveway because they had to have someone come down and plow it before they could get into it. That's what the vehicle looked like. What you can see, however, is the damage to the taillight, to the side of that taillight, consistent with it. So that hair, that 7/8 of an inch hair, was frozen to the side. And as you remember, the testimony from Sergeant Buchanan about the heated condition of the Canton Police Department garage, and that's one of the reasons that they took it there, because the other barracks that they could have taken it to didn't have that heated condition. So yes, after it's been in there from January 29th, about 5:30 p.m. until February 1st, when they conduct the search warrant, the hair isn't still frozen, as it's contained within heated garage, and the pieces of glass on the rear bumper have melted. The snow has melted, as you can see from left to right. The weather, also important, I would submit. Weather was
another point that I think is fairly insightful is, if you think about the length of the hair, what does it suggest? Let's put the ball in your court for a moment. If you think about the length of the hair that was found on the vehicle, what kind of hair do you think it was? And I think this is quite an important point. So there's a very short little hair found on the bumper. What kind of hair do you think it was? You think it was hair off his head? Certainly possible. but it could equally be an eyelash, an eyebrow. I was going to suggest an arm hair, but I think he was actually wearing a coat. But isn't it a hair from the face? I don't know if it would come from his chest, because remember, he's wearing clothing. Certainly arm hair is possible, but I think it's more likely an eyelash or an eyebrow hair, something like that.
As a weapon. Remember, the cause of death here is not just blunt impact injuries, it's blunt impact injuries and hypothermia. You heard all that medical testimony in relation to it, and you heard all that testimony in relation to the snow and the weather and the wind. Wind gusts up to 37 miles per hour while he's out, Mr. O'Keefe is out there in just a shirt and jeans. Now, you heard also testimony from Ms. Roberts in relation to the injuries she observed to Mr. O'Keefe, that initially on scene, there was one eye that was swollen, not the other. That's indication of the swelling that Dr. Scortibella was testifying to, and no indication of physical altercation. And then both eyes being swollen when Ms. Roberts viewed Mr. O'Keefe's body after his passing at the Good Samaritan. Submit that all the testimony tells you the same consistent account, internally, externally, from civilian testimony to investigator testimony to medical testimony to forensic testimony to the reconstruction testimony. You have the testimony from Ms. McCabe and Ms. Roberts that they couldn't see Mr. O'Keefe at Fairview when they initially pulled up. You can see that from Officer Sarif's cruiser.
Oh, I did hear a shirt, but I
covered in
seem to
snow
remember
from
seeing a
storm.
coat in the
You know
evidence.
where Mr. O'Keefe's body was. It's clearly visible on the cruiser camera from Officer Sarif. You have the testimony from each of the responding officers, anywhere from 5 to 12 feet off the roadway, and from the civilians as well. Ms. McCabe, Ms. Roberts, Officer
Could be a
Mulaney
beard.
has 6 inches of snow on Mr. O'Keefe when he first sees him. Firefighter Kelly says that he couldn't even see Mr. O'Keefe until he was 5 feet away, in the darkness, in the snow, in the blizzard conditions. There's no footprints around the body. There's no drag marks around the body. There's no evidence of anything in relation to Brian Albert and Brian Higgins.
So just to look at this quickly, as far as I know, he was wearing that hoodie, so it wasn't just a T-shirt.
Brian Albert and Brian Higgins spent January 28, 2022, traveling to New York City
Thanks, Ms.
to
Rex.
go to a funeral for another police officer, for another department, who they didn't even know. Traveled all the way down to New York and then came back before the blizzard, only to come back from that to go out drinking, come back to Mr. Albert's house, to then murder another police officer who they did know, who worked for the same department as them. And then criminal mastermind genius that Brian Albert is, 28 years on the Boston Police Department, he's then going to just leave Mr. O'Keefe's body on his front lawn? Really? That's the conspiracy.
That was one of the first things that I said. I was like, so the conspiracy is you kill someone and leave their body on your own front lawn, and that's framing someone else. I mean, isn't that framing yourself? And that is, to me, the biggest mind sort of fuckery I've ever heard, is like, so you're telling me that's how you'd frame someone else, is by leaving a dead body on your own lawn? And so it's like, I don't understand who thinks this way. Are we not in true crime where we can actually think properly? Somebody tells you this, and it's like, yeah, that's how you frame somebody? By leaving a dead body on your own lawn, you're framing somebody else. Okay. Okay, well.
Conspiracy? What evidence do you have of that? You have statements that the defendant made to Sergeant Buchanan on January 29th. She was willing to speak, but didn't want to give too much detail. Conversational tone throughout. She indicated that the night before, they had gotten into an argument, something about what was fed to the children, nothing about the detailed arguments and incessant phone calls and everything else that you saw from the defendant and Mr. O'Keefe's phone on the 28th. She indicated that she got to CF McCarthy's around 9 p.m., started drinking vodka sodas. The men were drinking beers. When asked where she parked her vehicle, she said she parked on Washington Street across from C.F. McCarthy's, facing northbound on the side, same side as Waterfall. Same testimony that you heard from Ms. Kolakithis, observing the defendant going over to her vehicle, getting in the driver's seat, and the victim, Mr. O'Keefe, getting into the passenger seat. She said they were left the Waterfall, were invited to her residence. She drove her and John to the location in Canton. She dropped Mr. O'Keefe off, did not see him walk into the home. She, being the defendant, stated she made a 3-point turn and then left. When asked about the damage to her vehicle, she indicated to the troopers, "I don't know, it happened last night."
Yeah.
June 2022, you have that other recording of that other version that she now has evolved into, as far as stating to Sergeant Buchanan, "Are you aware that John was beaten up by Brian and Colin Albert? We're all in on the same joke, right? John was pulverized and my taillight was cracked." What evidence do you have of that? Mr. O'Keefe never went in the house. You have testimony from Nicole Albert, Brian Albert, Jennifer McCabe, Matthew McCabe, Caitlin Albert, Brian Albert Jr., Sarah Levinson, Julie Nagel, all indicating never went in the house. John O'Keefe's phone never went in the house, from the testimony and the data points that you have from Trooper Green. You know how Mr. O'Keefe was dressed, and you know the defendant knew.
That to me is a point he needed to emphasize a bit more. So the defense said, because it looked like he went up and down stairs, that means he went in the house, right? But if you think about it, what is stronger evidence? A fitness app saying that I went up and down, or a cell phone indicating that after 12, I think it's 12:35, 12:37, it doesn't move after that. The cell phone, the cell phone's got GPS and so on. The cell phone indicates that after 12:35, 12:37, the phone doesn't move. And so if you want to compare the evidence, which one are you going to choose? And I think in a way that the whole case revolves around this kind of argument. The cell phone says this, it's really strong evidence. Oh, but the fitness app says that. Isn't it quite strong evidence as well? And then you say, well, that's reasonable doubt. If you're a bit ignorant, it's reasonable doubt. If you have common sense and you're able to think in an integrated fashion, then it's not reasonable.
That. You have the testimony from Kurt Roberts, Jennifer McCabe, Matthew McCabe, Karina Kolakithis, Nicholas Kolakithis, Brian Albert, Cole Albert, Brian Higgins, all indicated in the testimony, and the defendant knew, based on our questions to the firefighters the next morning, that Mr. O'Keefe was not dressed for the weather when he left the Waterfall. The weather was a weapon.
Somebody says hi.
You have the testimony about the car, the defendant's car being there in front of the house, moving multiple times. You have that from multiple sources. You have that from Matthew McCabe. You have that from Jennifer McCabe. You have that from Brian Albert Jr. You have that from Julie Nagel. You have that from Ryan Nagel. You have the testimony of Ryan Nagel, Ricky D'Antona.
Give me a high five.
Ms. Maxson indicated she saw a male passenger, female operator as the vehicle was turning. Remember, they're coming towards Fairview at the same time. The defendant, after conducting that reverse, a 3-point turn on Cedar Crest, is then taking a right onto Fairview, while Mr. Nagel, Mr. D'Antona, and Ms. Maxson are taking a left on. Mr. Nagel indicates that Mr. D'Antona then flashes lights. During that time, Ms. Maxson can see inside the vehicle. She sees a male passenger. She sees a female operator.
I must say I'm really grateful to you guys, but I'm also glad that I feel like I've created a community here that is reasonable, mature, and sensible. And that's why I can cover a case like this, and it's not open warfare, and it's not horrible. I mean, I'm not having a horrible time presenting it. I'm not being sworn at or anything like that. And thanks to you guys. Thanks a lot.
Follow the vehicle as they're turning onto the street. Lo and behold, they're going to the same residence. They park. There's nothing in between them and the defendant's vehicle. They indicate that at no time do they see anybody get out of the vehicle. At no time do they see any damage to the vehicle, or it hasn't happened yet. At no time do they see anyone leave the vehicle and go into the house. The vehicle moves up on different successive occasions, as testified to by Mr. Nagel and several others. And then as they're passing that vehicle, Mr. Nagel indicates that he sees a female operator in the vehicle with the dome light on. Interesting, when I asked Mr. Nagel, as far as when Julie Nagel came out to the vehicle, did he roll down the window or did he open the door? He indicated he opened the door. And I asked him, what happened when you open the door? What happens when you open the door to a vehicle? The dome light comes on. So there's a reason I would submit, or the inference that you can make, is that no one sees Mr. O'Keefe in the vehicle because that's the moment he steps out of the vehicle. And then they're gone. The Nagels, Brian Nagel, Ricky D'Antono, and Heather Maxson drive away from that. We heard the testimony from Julie Nagel and Sarah Levinson, the peanut butter and jelly sandwich conversation they have with Ms. McCabe, which while they're pulling away from the house where everybody's attention is drawn, Ms. McCabe is turned around facing both of them in the backseat. Ms. Nagel is facing Ms. Levinson on the passenger side, looking out the window towards 34 Fairview Road. Ms. Levinson is looking back at Ms. Nagel away from that area, in which Ms. Nagel indicates that she sees a 5 to 6 foot dark blob on the lawn near the pole in the hydrant, which is just where Mr. O'Keefe is discovered the next morning. You have testimony, recall, and you have text messages in regard to Colin Albert when he gets picked up.
Mr. Lally, 5 minutes.
Yes, sir. Colin Albert, Miss Allison McCabe, Brian Albert, Nicole Albert, Caitlin Albert, Brian Jr.
I don't know if you saw these two behind him, just looking at their watch just before that was announced.
All indicating that it was picked up around that time at 12:10 a.m. You have the testimony from Chris and Julie Albert, his parents, as far as when he comes home, kisses them goodnight before he goes to bed. You have that testimony in regard to Chris Albert, as far as how John O'Keefe and the defendant come to be at the waterfall in the first place, as far as John O'Keefe and his nephew coming in earlier in the day, getting a couple slices of pizza, what are you doing later on, contained within those testimonies. You have the testimony from Lieutenant O'Hara, Lieutenant Tully, Sergeant Mechanic about those items being recovered. And in particular, the items being recovered on January 29th by that search. What did Lieutenant O'Hara say? The items were found close to the curb. The items were at ground level. 3 feet of snow that they had to sift through in order to find those particular things. The detail or the delay in the recovery of evidence. The photos in the video, most of which you have in evidence, is earlier in the storm. This is before the 18 inches of snow falls down, before there's drifts and 3 feet of snow in places. They found the evidence where it had been at that same ground level, in the grass, under the snow, at 34 Fairview Road. We heard all of the medical testimony, which I would submit is consistent, from firefighter Formati to Dr. Rice. We heard testimony regarding the defendant's blood alcohol concentration for Dr. Fowler and Nick Roberts, 93 milligrams per deciliter, 0.07 to 0.08% at 9:08 in the morning. We heard it, Mr. Roberts' testimony in regard to the retrograde extrapolation, 0.13 to 0.29, extrapolating back to the time of the operation. The defendant admits to drinking vodka. It's on the receipts.
Who do you think was more? I would give the exact same number, Chelsea. Who do you think was more intoxicated between John and Karen?
Of McCarthy's and from the waterfall, and you have the witness testimony in the surveillance video in regard to the forensic testimony that you have. In regard to the medical testimony, you have the sort of pattern abrasions, the clear plastic that's recovered by Lieutenant O'Hara and Lieutenant Tully on January 29th. The clear plastic that has the dimples on it. No one, not Trooper Paul, not anyone, at any point in time ever said that Mr. O'Keefe's arm was out like this at the time that he struck and that he did a pirouette and then flew 30 feet in the air. 12 inches of abrasions that the doctors were, the biomechanical people were talking about yesterday. 12 inches and then 6 inches for the tail end is easily solved by this. And the dimples on his arm are, that I would submit are consistent with the dimples on the tail light cover piece, are right around this area of the elbow. You have the testimony in regard to forensics as far as Mr. Porto, Mr. Bradford. John O'Keefe's DNA is on that taillight housing. On the house, his DNA is there to the exclusion as well of Sergeant Mechanic and Trooper Crocker. Mr. O'Keefe's DNA is on the exterior of the broken drinking glass. Mr. O'Keefe's DNA, and only Mr. O'Keefe's DNA, is on his clothing and his fingernails, consistent with Dr. Scortibello's testimony that there is no evidence of a fight or an altercation. There's no one else's DNA under his fingernails. There's no one else's DNA on his clothing. You have the testimony from Ms. Hartman, Trooper Paul, as regard to the damage that they observed, the dent, the scratches, the 7/8 of an inch hair. You have the testimony from Ms. Chart in regard to the mitochondrial DNA profile from that hair being consistent with the DNA profile of Mr. O'Keefe. You have the testimony from Ms. Valier and Ms. Hanley in regard to the microscopic pieces, 1/16 of an inch by 1/16.
You have 1 minute, Mr. Lally. Wrap it up.
Yes, Your Honor.
Whoa.
All consistent with pieces of taillight that are found within his clothing.
He kind of needs to not look at his notes and just conclude, just say, guys, right? He needs a proper polished conclusion, a summary, yeah, wrap it up.
Ms. Gilman, if I could.
He seems a little thrown, eh?
605, this is what this vehicle looks like backing up at that speed for approximately that distance.
Well, this is kind of the coup de grace. This is kind of what you really needed all along, is a recreation, a reimagining. I think he's going to show the speed of a vehicle backing up, how fast it actually is.
There's another, years and years ago, started practicing in Norfolk County, in Braintree, what is now Quincy.
Oh.
Eventually became a far smarter man than myself. Eventually became President of the United States. His name was John F. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence. What the constellation of the facts and the evidence ineluctably demonstrate here is that the defendant drove her vehicle in reverse for 24.2 miles per hour for 62.5 feet, struck Mr. O'Keefe, causing those catastrophic head injuries.
I mean, just that, the fact that her vehicle moved at that speed in reverse on its own is incredibly damning. If you're saying, was this guy struck by a vehicle, or is there a big conspiracy? Why is the vehicle moving at 24 in reverse? If there was no in reverse, then it would be quite hard to make that case. I really like how eloquent he is in this quote that he's reading at the end.
Leaving him incapacitated and freezing to death.
Mr. Lally, I have to stop you. You've gone over. Okay.
I literally have one sentence on Joe.
One sentence I'll give you.
From that facts and that evidence, I would submit ineluctably demonstrates her guilt on each of the indictments before you, and I would ask that you find this. Thank you.
All right.
Okay, I must say, not a very good ending. You do need to stay in the time frame, but overall well presented. But I'm sure the haters are going to have a field day with that. They're definitely going to enjoy, because that was a bit of a mess, the ending.
All right, thank you. Jurors, I have my instructions on the law I'm going to give you. My guess is it's probably about an hour. I'd like to start it now, but does anybody need a short break? We can take a short break. Okay, we'll come back in 5 minutes.
Leaving your notebooks under your chair. All rise, jury up.
You are muted.
Okay, and using the magic of the internet, we're going to jump ahead in time 5 minutes. Shall we do that?
The law. The instructions divided into three parts. The first is general instructions that are provided in every criminal case. The second, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations.
Now, I must say, in terms of a case that's about evidence versus the allegation of incompetency, that certainly wasn't a good look for the prosecution. It almost is like, oh dear, all of this all again. It's, you know, do you guys want to go through these jury instructions?
Fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt.
So you can have possible doubt and imaginary doubt. There can be a little bit of, I'm not sure. So it's not reasonable doubt at the exclusion of doubt whatsoever. Important to be clear about. In other words, not completely black and white, not absolutely simple. Just that the, how can I say it properly? That the overall burden has been met of proving your case beyond reasonable doubt.
A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, how do you decide whether the Commonwealth has proven each element of an indictment is true beyond a reasonable doubt? Let's talk first about the roles we all have. You folks are the most important people in the courtroom. It all begins and ends with your function. You will determine the facts in this case, and that is your job and your job alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must determine the facts solely and entirely on the evidence as you have heard it and seen it in this courtroom and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion or sympathy, passion or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I've given it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged, or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Now, your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in this case. However, I have no opinion about how you decide this case. You should not consider anything I have said or done during the trial as reflecting any opinion by me about how you should decide this case. If you believe that I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on the evaluation of the evidence. Now, the arguments of the lawyers are not evidence.
These are Karen's parents. I thought her father made quite a huge gaffe on television, and I thought that she did as well. Was that ever played during the trial, the interview that she gave?
Are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter.
It's quite a profound idea. The jury's collective memory. And, like in a way, I feel like where we are as a culture and a society, how good is our collective memory of what we know, what we hear, what we observe, what we told, in short, of reality? How good are we collectively in terms of our memories as jurors, as litigators of reality? Are we reliable? Are we reliable enough outside the courtroom?
Lawyers' objections are a proper part of the court's procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They are simply doing their job during a trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. Now, the verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits in the case. There are some things you have heard about that have not been introduced into evidence, such as written statements by witnesses, police reports, autopsy, and accident reconstruction reports. Occasionally during the trial, you have heard references to such documents, and you may naturally wonder why neither side introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you view exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed or why. Any information that you may have read, heard, or seen about this case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements, and any comments they may have made are not.
So, Liesel, surely that would have happened now. Is there going to be another 10 to 15 minutes for the defense and then for the prosecution?
Evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to questions, and the exhibits are evidence. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case.
So, what do you think about that? I know it's something that's not news to us, but your verdict shouldn't be based on emotion. Then you think about the crowds out there, they're wearing pink shirts. they're clapping their hands, they're cheering. Is that kind of, is that emotion, or is that someone who's acting out of being educated and informed? Should trials have cheerleading squads on both sides? The side with the most pink or blue shirts wins. Is that how court should be decided and trial should be decided? If the victim is pretty, you sympathize with them. If they're not, then you don't. Is that how trials should be conducted?
Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in this courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment
and critical thinking. Now, if you think about it, the jurors are expected to behave without bias in a trial that is all about bias. This trial is all about, I don't like the police. This witness is ridiculous. Ha, ha, ha. It's pretty incredible. It's pretty incredible. The bias I've seen in this case is, I think I last saw it in Depp versus Heard. And so the jurors must act without bias. Do you think they can? Do you think they will?
and to decide the case based solely on the evidence and the application of the law to that evidence. I have allowed you to take notes during the trial, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with other jurors. Consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Please keep an open mind until then. You'll remember that we took a view in this case.
If you think about it, it is quite a tall order that the jurors are expected to still have an open mind. Do you think they do?
The purpose of the view was to help you better understand.
Do you?
And the evidence that you heard during the trial, and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness?
What about the demeanor, candor, and appearance of opposing counsel? I heard someone saying, I might be slightly off when I say this, that there was a debate, I think, between Nixon and JFK, and Nixon had a couple of hours of 5 o'clock shadow. It was televised, so it was televised, and so they say that counted against him. That was rumored to be part of why he lost, was because he had a bit of 5 o'clock shadow. And look at Lally. He doesn't have all of his hair. Does that mean is that going to count against him because he doesn't look as snazzy as the other prosecutor? I mean, I thought he did a better closing, except for the last 2 or 3 minutes. Should that count against him because it didn't appear? It's not about what he argued, but how it appears. Unfortunately, people are quite susceptible to appearance. They say don't judge a book by its cover, but we all do, and to some extent we all should. Don't judge a book by its cover, but of course you do. Of course you should. You shouldn't just judge everything about the book simply by its cover. Start with the cover and then go on.
What relationship do they have to the case or to the other witnesses or the parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witness and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate.
So I want to ask a quick question. We at like a very important point in this trial. Do you think the jury are gonna get this verdict right? Do you think the jury are going to get this verdict right? Which is another way of saying, do you think the jury are completely unbiased? Do you think this jury are going to get the verdict right? Fatika says yes. Okay. And the reason I'm kind of asking it is, do you think juries are becoming more biased and less reliable? Do you think communities are becoming more biased and more tribal? Do you think people are becoming more susceptible to populists who tell them what they want to hear? And where does this take us as a society collectively? Or doesn't it take us to bias and prejudice being kind of very much ingrained in who we are? And then you say, well, what is the future then of juries? Are they going to become less and less reliable? Or are juries do you think juries are going to become less and less reliable or not? Because quite a few of you are saying no. 1, 2, Ison says there is room for doubt. A couple of you say no. And I'm going to say something that'll probably shock some of you. If you reach a point where you start seeing verdicts that are legally, let's say, indefensible, and you say we actually can't rely on people have become too biased. Bear in mind, in South Africa, we don't have juries. And I think the reason for that is, I could be wrong, but I think the reason for it is because of the racial makeup of South Africa. If you've got a white defendant and a black jury, or vice versa, it's just too loaded with issues, and so you'd rather put it in the hands of a judge. Judges in South Africa decide the outcome, and then if it goes to the Supreme Court, there are 5 judges who are often of different backgrounds. That's how they sorted out their thing. But maybe in the future, you would need to maybe consider, like I mentioned this to a lawyer, you would maybe have to consider, how you have a referee in sport where you've got a digital system that basically tells you was the ball in or out or whatever. In other words, and that is used as a guide to help the umpire or the referee make up his mind. What if you could have something like that in a trial where you have the jury's verdict, but the judge can also refer to, let's say, AI. You feed all the information into the AI. And yeah, I mean, you could say, yeah, but isn't the AI going to be biased? I don't know. I don't know how you would design the kind of AI that could do this, but I assume that it is certainly possible. In other words, you put all the evidence that's common cause on both sides and then see what the AI comes up with. Just as a guideline, not to overrule everything. What do you guys think of that? You're probably rolling your eyes, right?
Accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for that purpose. Now, you've heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted test or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth.
When I studied law, what was sort of drilled into us was the reasonable man test. And I still think it's such a fantastic measure where you basically say, what would a reasonable person, probably these days it needs to be person, not man, a reasonable person, what would a reasonable person do in this situation? And so apply it now to Karen Reid. Would a reasonable person, for whatever reason, need to reverse at 24.2 miles per hour in a kind of a blizzard or a snowstorm on icy roads? Would a reasonable person drink 9 drinks or whatever it is? Would a reasonable person leave the kind of voicemails that were left? Would a reasonable person say, I hit him if they didn't hit him? Would a reasonable person this and that, and you can go on and on and on. Is it reasonable to assume that 50 people would participate in a conspiracy? Is it reasonable to say that the firefighters are part of a police or the paramedics are part of this police conspiracy?
All of these considerations involve factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. Now, during the trial, I gave you some limiting instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I am going to summarize those limiting instructions here. Ms. Reid is not charged with committing any crime other than the charges contained in the indictments. You have heard evidence about interactions that Ms. Reid had with Mr. O'Keefe and other witnesses in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29th, 2022. You may not consider that evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must also have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored them were, in fact, John O'Keefe, the defendant, or the witnesses who testified about their communication with John O'Keefe and or the defendant. If you do not find it is more likely true than not that John O'Keefe, Karen Reid, or the witnesses who testified here before you were the persons who authored or transmitted the electronic communications, then you may not consider the electronic communications in deciding the case. Now, the Commonwealth has introduced photographs into evidence. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You've heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's cell phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that the defendant was aware of John O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you reasonably can infer from the evidence that she did learn of it. You've also heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she is alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence that you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witness testimony that I mentioned earlier, including any bias or motive these opinion witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training, and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of these witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the assumed facts are true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. Now, you have the same powers with respect to the exhibits that you have and the testimony of the witnesses. Look them over and decide the weight, that is the value they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it is written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what the exhibit purports to show and how much weight, if any, you give each exhibit. Now, you've heard me talk about the sources of evidence in this case. Those are the tools that we have to decide the case. Now, with the evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe, because you are entitled to rely upon both direct and indirect or circumstantial evidence.
I don't know if you noticed that Karen wrote something on a piece of paper and the court TV camera zoomed in, but in order to cut out what she wrote, that can cause a problem if the camera, it's a kind of invasion of privacy. I'm not terribly happy about this part of the laptop being visible. In the Troconis trial, you may remember there was this allegation that communications were possibly being sent to the gallery by having laptops open and text being a certain size. There's all sorts of funny things going on sometimes in trials that one's got to be wary of.
Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Circumstantial evidence exists where a witness does not testify directly.
You kind of got to wonder what he makes of, can he see, I don't know if he's too low, but can he see what's being written over here or what's on this laptop? It's not a very private courtroom, is it?
To the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference?
Did you hear that? Circumstantial evidence is competent, is sufficient, if there's enough of it, to establish guilt beyond a reasonable doubt. I've so often heard, I wonder about whether you've heard the same thing, where defense attorneys say very unambiguously, this is only a circumstantial case. There's only circumstantial evidence. Well, most cases tend to be that. Most cases tend to have mostly circumstantial evidence. But they say it in a way that, oh, well, circumstantial evidence is not enough to convict someone. Wrong. It is enough, if there's enough of it. If the mosaic is... And a good example of a circumstantial evidence case is Laurie Vallow and Chad Daybell. A lot of the evidence is they pray, they send text, someone becomes a zombie, that person dies. They pray, someone becomes a zombie, becomes this number, and that person dies. Circumstantial, but the pattern repeats itself.
An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seems more reasonable to you. Remember, when you are dealing with inferences, you never have to infer anything. You may, but do not have to draw any inferences whatsoever. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household, a child, roommate, or spouse, hands you the mail and states that he or she observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the event with his or her own senses and told you what he or she observed. The issue you would have to decide is whether the witness is credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case, not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I have just described. You may have noticed that the defendant did not testify at this trial.
What's the difference? Yeah, that's also quite important. Do you draw an inference from that? What's the difference between speculating inside a courtroom and speculating outside? Well, speculating inside a courtroom has consequences. Speculating outside a courtroom also has consequences, but they are seldom enforced. And I suspect that the speculating outside the court is by design and is meant to actually influence the jury. I suspect that that's not innocent. I suspect that the online thing that's going on isn't, if you're saying there's a conspiracy, isn't that a conspiracy as well?
The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that the defendant did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based.
I don't know. I would have a bit of a difficulty with that. I understand that's the rule, but it would be quite hard for me to say, so this person was accused of a crime, they're innocent, but they didn't really want to testify on their own behalf, and don't draw any inference from that. It seems a bit unfair.
Solely on the testimony of the witnesses and the exhibits. All right, that completes my first part of the instructions. Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. Ms. Reed is charged with second-degree murder. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of.
So this definitely creates a bit of a problem for Karen. She's not charged with one thing. There are several counts against her, which, if the jury are vacillating, to use a word that came up earlier, if the jury are uncertain, well, they can gravitate to a greater or lesser charge. We'll see whether that happens.
Of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe, or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 subparts, which I will call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily.
So what do you think about that? Did the defendant intend to kill John O'Keefe? Or did she intend to hurt him? What do you think the answer is? And what definitely is a tricky element here is, if you're intoxicated, do you have intent? If you're able to drive, are you able to think? If you're able to drive, are you able to form an intention? So does the intoxication play a role in diminishing intent? Conversely, did the alcohol or intoxication actually intensify an intent that was there already?
Bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result.
So Pauline says, I don't think she intended to kill him. So if she didn't intend to kill him, shouldn't she be filled with remorse? If it was like she killed him by mistake, if that is what happened, shouldn't she be filled with remorse and regret? And shouldn't there be a lot of almost turning to his family, I'm so sorry? Is there any of that if she didn't intend to kill him? And vice versa. If she did intend to kill him, what would you expect?
Let me help you understand how to analyze this third prong.
Hi, Earth.
You must first determine whether the defendant intended caused the victim's death.
And that is a somewhat tricky question given the circumstances. I know what I think, but I'm it's kind of clear that it's not necessarily a simple or easy question.
If you find that she intended to perform the act, you must then determine what the defendant herself actually knew.
You must also think about, if you intend to do something, let me put it another way. If there's intentionality in covering up something, why are you covering something up when you didn't intend to do something? You don't need to cover up an accident. And so if you go to a lot of effort to cover something up, what are you covering up? Are you covering up something small or something big? If you drive at 24 miles per hour in reverse, does that show slight intention, medium intention? What does that show? And another way of thinking about it is dolus eventualis. You acted in a way, you may not have had a direct intention, but you should have known that what you were doing could have caused serious harm. I'll give an example. If you throw a firework into a room where there are people inside the room, you're not really intentionally doing something against a specific person, but you ought to have known someone would have gotten injured. That's a kind of intent as well. I would have liked to have seen an argument like that made during this trial anyway.
About the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether Mr. O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more.
So think about that mirror. Do you have an intention? Is there intent? And then how about the intention afterwards to make things appear a certain way? I'm talking about at the scene, but also subsequent. Can you argue that the alcohol kind of just wears off and suddenly there's remorse? Suddenly, so there's something like that.
More of those elements beyond a reasonable doubt, you must return a verdict of not guilty. The next is manslaughter while operating a motor vehicle under the influence of liquor. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was a 0.08 or greater. You'll have both these choices on the verdict slip. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. And fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. So to prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the well-known things that drivers do as they
Was the defendant operating a motor vehicle?
Travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was a 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they've consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that their ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this first theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed any alcohol. However, no matter what the reading is, the blood test is not sufficient itself to prove that the defendant was under the influence of alcohol. Now, under the second theory, and again, both will be on the verdict slip and you should decide each one. The Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was a 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test. Mr. Court Officer, I know it's traditional to not allow anybody in and out of the courtroom while I'm charging, so I'm going to ask you to follow that at this point. Thank you. It's distracting, and I don't want it to be distracting for you folks, okay? The fourth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently. That is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger or death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved the element. Here, the defendant must have intended her acts in the sense that they were not accidental, but it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in the category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition and how well the defendant could see and could control the vehicle, the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what was the time of day, the weather and the condition on the road were, and what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all five elements beyond a reasonable doubt, you shall return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. So I will define involuntary manslaughter. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. Third, that the defendant's conduct was wanton or reckless. I will now discuss each element in more detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another person that a person undertakes with indifference or with disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined them. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and negligence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. So I will define that for you now. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as I've previously instructed you just moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people.
That's why I say, this is a heck of a lot for a human being to have to balance in a totally absolutely fair and equitable way, can they?
A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not
Oh, wow, she's saying what I said earlier.
do under the circumstances, or by failing to do something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that could have avoided, that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or may not have intended to result from her actions is irrelevant. The issue is whether...
I wonder if Juror could sort of say, sorry, Judge, I just stopped concentrating for a while, and then, but so I can't say exactly when, like somewhere when you were reading that, I zoned out. I just think for the sake of completeness and just to be sure, do you mind reading everything again? Because I don't want to miss anything. Like there was a moment somewhere when you read this, I just kind of zoned out, and I can't tell you exactly where it was. Can we just please go through it all again?
Or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of road it was, and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The next indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated on a public way or in a place in which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. And fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed you on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define them any further. Save a little time for you. As a general rule, you are permitted but not required to infer that a person who intentionally...
Okay, I'm going to skip ahead about 4 or 5 minutes just to the last bit of this. Okay.
All right. So, ladies and gentlemen, we need to swear in the court officers. They're going to be in charge of you during your deliberations. I suggest that you listen to the oath that they are taking so that you can be aware of their responsibilities. Now you can swear them, Mr. Clerk.
Okay, we're not
You
going
swear
to
that you will keep this
do
jury
the
and
court
alternates in
officers.
some separate but convenient place until they agree, that you're not suffering any
Sorry, guys, I've kind of got to get back to another case that I'm working on. I don't want to go beyond that
So,
4
counsel, I'll
hour
give you a
30
few minutes
mark.
to work with Mr. McDermott on the
verdict slip, and then I'll come back out.
Thank you, Your Honor.
All rise for the court, please.
Okay, so that is it. Closing arguments of this day into the 31st day. It's been a really long trial. I just want to express my appreciation to the chat. Guys, you've been really great. It's been good having you guys here. While the poll is at its highest level yet, 42% saying, I think she's guilty, 58%, I think she's innocent, 315 votes. So definitely quite interesting. For those interested, in terms of the Jay Slater case, this is the cover that will be going up. I think it's this. No, not that. Is it this one? So this is the cover for the next episode in terms of that. It is dealing with the Jay Slater case. I'll be going into that from here. My graphic designer was actually in my office a little bit earlier and took this photo of me. So that's going to be the new cover art pretty much for my channel. So some exciting things coming up. There's also some new emojis for the Team Peachtree channel. That sort of thing. So that's, you recognize who that is? Anyone know who you can see there on screen? A couple of peach emojis, the surprised peach. Also an excited Timmy. Random 1 a.m. Thanks a lot for being here. Sad Peach. So just something to look forward to on the Team Peachtree channel. Anyway, that is it from my side, guys. I hope those of you who've been following the Jay Slater case will check out my analysis on that coming up a little bit later. Thanks so much for joining me. Chelsea, a great job being in here as well. Thanks so much. Here's another emoji just before I go. This is Angry Timmy. All right. And one more. What was the other one? Angry Peach. So some emojis coming up on the Team Peachtree channel. Okay, guys. Thanks again for joining me. Thanks for voting in the poll. And now I guess we're going to await the verdict in this case. I think all of us are a little bit on tenterhooks. Thanks everyone for being here. I appreciate your thoughts and your comments. Thanks for the couple of super chats. Also, thanks to Liesel, who came into chat for a while. Liesel's a qualified lawyer. We always like to have qualified folk talking about the legal aspects. Anyway, yeah, thanks a lot, guys. Take care. See you guys next time.